Hey, everybody. Welcome back to the Law of Self-Defense. I am, of course, attorney Andrew Branca for Law of Self-Defense, a small law practice based out of Colorado that provides legal consulting and educational services exclusively on use of force law, meaning self-defense, defense of others, and defense of property. Come on in, everybody. Make yourselves comfortable. As usual, I'm scrambling a little bit to do a ad hoc live show. I get a lot of requests to schedule these on a regular basis, uh, like many other YouTubers do. Unfortunately, folks, it's hard for me to do that. I have actual legal work to do from time to time. Other projects we have scheduled, and sometimes these live shows are just driven by the time allowed and circumstances and what's happening out in the real world. And today what's happening is I noted that this morning the defense in the Michael Barisone trial has brought to the stand as their defense witness a psychiatrist who presumably will testify on the matter of the insanity defense for Michael Barisone. So that's what I wanted to chat with all of you today. That happened a bit earlier this morning, so we'll be watching the recorded playback of that psychiatric testimony, that expert witness testimony. But we're not that far behind. And meanwhile, perhaps we'll get through some of the past some of the delays and maybe see what's happening this afternoon. I'm still waiting to see if Michael Barisone will be called to testify in his own behalf, which I would normally think would be necessary given the apparent lack of other evidence in support of the perfect self-defense of self-defense in this case. But Barisone himself claims to have no actual personal knowledge of firing the shots that were supposedly fired in self-defense, so that could be awkward. So I am catching up a little bit. So the psychiatrist's name is John Bascara, doctor, psychiatrist, so MD, so a real doctor, not one of these, Jill Biden doctors. So John Bascara. And so let's do a quick review of this case. Come on in, everybody. By the way, folks, just a reminder, if you could please, there's only 50 of you here right now, but if you could please hit that subscribe button if you haven't already, that would be extremely helpful. Hit the bell if you want notifications. YouTube sucks at giving out notifications. Not much I can do about that, but you certainly don't stand any chance of getting a notification if you're not subscribed and don't hit the bell. If you could hit the like, thumbs up, and leave a comment, even if it's only your city and state, that's always appreciated because it helps fool the YouTube algorithm into giving my content here more attention than it otherwise would get. As you might imagine, YouTube is not favorably disposed to my work. I don't know why, but that's just the way it is. So sometimes we have to trick the algorithm a little bit. If you could hit that like, thumbs up, leave a comment of any kind, and tell friends and family about these shows if you like them. That would be awesome. We did just break 30,000 subscribers on YouTube, which to me is shocking. I can't believe there's 30,000 of you who want to hear me blather away on use of force law this frequently, but I'm very humbled and grateful for all that support. I really do appreciate it, as does Mrs. Branca. Emily is eagerly planning out our next trip to Disney. So that's what are you going to do? And on a more personal note, while we're waiting for more people to filter in, maybe get these late notifications to this ad hoc live meeting. Some of you may know, especially if you follow me on Instagram. By the way, I'm on all the social medias. I don't necessarily spend a lot of time on all of them, but I'm on all of them. So whichever one you're on, you can find me there simply by using the URL lawofselfdefense.com/ whatever the social media is. So lawofselfdefense.com/YouTube will get you to this YouTube channel. lawofselfdefense.com/Instagram will get you to our Instagram channel. lawofselfdefense.com/Facebook/Rumble/locals/Spotify. You see how it works. But if you do, I know Disney is awful, but we planned and paid for the trip long ago, so not much to be done about that. If you do follow me on Instagram, you may be aware I've been on a fitness regimen for the last 3 weeks. I had ballooned up to, believe it or not my heaviest weight ever, but pretty far up there, 222 pounds as of March 15th last month. The Ides of March were hunting me down with their bloody knives, and decided, well, that was enough of that. The trials I'd been covering so intensely for the prior 6 months, Rittenhouse and Potter and Curtis Reeves and Edgecombe and all that, had finally given me pause where I could not be spending 15 hours a day at my desk, but finally get back on the treadmill. So I started that on March 15th, 222 pounds. That was 3 weeks ago today. So Tuesdays, I do my public weigh-ins to keep myself publicly accountable. Now, I will say that for 5 days of the last 3 weeks, I was at TACCon 2022, Tactical Conference down in Dallas, where there was no exercise, there was no intermittent fasting, and there was no caloric restriction. It was steak dinners, it was socializing over drinks, it was food truck lunches. So I did take a couple pound bump during that 5-day period. Believe it or not, 2 pounds in 5 days. But today I did my weigh-in for the comprehensive 3 weeks since March 15th to today, April 5th. And the results are in. Do we get a drum roll? Somewhere here I have a drum roll. There we go. That's the one I was looking for. So today the results are in. On March 15th, I weighed 222 pounds. This morning on April 5th, I weighed 212 pounds. Thank you very much. Thank you. I really appreciate that. So 10 pounds in 3 weeks, including a week in which, one of those 3 in which I actually gained 2 pounds because I wasn't in the program. The program, by the way, is, for me personally, is a combination of intermittent fasting. So I don't eat until between the hours of about 9 p.m. and 1 o'clock the next day. So it's not that bad. Basically it's a late lunch, no breakfast. I don't really get hungry until the last hour or so before that. So that's the intermittent fasting. And then caloric restriction. Caloric restriction meaning I only eat about between 1,000 and 1,500 calories a day of food. And then 3 times a day on the treadmill, just old man jogging stuff, nothing fancy, but it adds up to about 1,000 calories a day in exercise. So do that consistently, and you can lose about, or at least I lose about 3/4 of a pound a day, pretty consistently. Now, I'm not a nutritionist. Please don't take diet or exercise advice from me. I have no idea if my personal program that works for me would kill you. So do whatever is best for you, of course, but that's just how it's working out for me. So with that out of the way, let me jump into the intro video for today's program, and we will get started on a review of the facts, the law, the case as it's gone so far in the attempted murder trial of Michael Barisone. Here we go. The screen. Oh, there I am. Awesome. All right. So we're talking about the Michael Barisone case. Let's see. I got a heck of a reflection today. There we go. The Michael Barisone case. Michael Barisone is a horse trainer. He's got a horse farm. I will call it a horse farm today, folks. Feels weird calling one of these places in New Jersey a ranch. We got lots of ranches out here in Colorado, not so many in New Jersey, I expect. But Michael Barisone is a horse farm where he trains people and horses in the art of, or the sport of dressage. Dressage, I have no idea what that is, but apparently some kind of fancy horse riding. Michael Barisone was himself an Olympic level competitor in dressage. Now in later years, he has his horse farm and he trains others and horses on how to do whatever dressage is. One of the people he undertook to train was Lauren Kanarek. Lauren Kanarek apparently aspired to do dressage at a high level, so she went to an Olympic level trainer for that purpose. She was in her 40s when all this went down, and obviously older than that now. This was about 4 years ago at this point, almost 3 to 4 years ago. And she brought with her boyfriend, Robert Goodwin, and relationship between Michael Barisone on the one hand, and by the way, Michael Barisone invited them to live on his property. So they were living in a home on his property, kept their horses on his property. That made them tenants. And as tenants, they have certain rights to stay on that property once they've become tenants. Evicting people can be very difficult, especially in New Jersey. Even once if you just tell them to leave, that does not oblige them to leave. And even once you start a formal eviction process, it can take months before they're actually evicted. And in this particular instance, there was no formal eviction notice until just before the violence culminated in this relationship. And the relationship between Michael Barisone on the one hand and Lauren Canarak and her boyfriend Robert Goodwin on the other quickly became extremely toxic, unimaginably toxic between them. Lauren Canarak and Robert Goodwin are, by all appearances, absolutely terrible people, said absolutely horrible things about Michael Barisone, deliberately intended to destroy him emotionally, psychologically, reputationally, professionally. On the witness stand, they had no hesitation conceding that they were basically torturing Michael Barisone in an emotional and psychological sense. Including doing things like calling local authorities to his property to find code violations, getting him kicked out of his house as part of that code violation process. So he was living on a mattress on the porch of his barn. This is the guy who owns the property. So they were very malicious towards him. Lots of vile social media posts by Lauren Canarak about Michael Barisone. And she's just fine admitting that, saying she said all those horrible things about him. I mean, from her perspective, it appears that her view is social media is for shit posting other people, and she was shit posting Michael Barisone. Too bad. It doesn't justify him shooting me, and that's what happened. So ultimately, this toxic relationship culminated in a confrontation in which Michael Barisone shot Lauren Canarak twice in the chest. She would survive those wounds, those gunshot wounds. Obviously, she testified at trial later, and he would shoot at Robert Goodwin, the boyfriend, miss him, but shot at him. And these firing of the shots would result in 2 counts of attempted murder charges against Michael Barisone, including, of course, this being New Jersey, and he used a gun. He's also facing a gun charge as well. The gun charge by itself is probably good for 10 years. The attempted murder charges, if convicted, are probably good for life in prison. He was actually offered, Michael Barisone was offered a 10-year plea early on, rejected that plea. That strikes me as not the most prudent decision in the world because, like I said, the gun charge is probably good for 10. And he's got no defense against the gun charge. So he was going to do 10 no matter what. And now he's looking at life. So what are his possible legal defenses here? Now, I know the soap opera Telenova contingent of legal analysis out there on the internet feels that he should have been privileged to shoot these people simply because they were horribly mean to him. They were bullies. They were monsters. They were intent on his destruction in an emotional and psychiatric sense. And okay, we may wish we lived in a world where you were allowed to shoot people who were that mean to you, but we don't, in fact, live in that world. We live in a world that has specific legal defenses that can be raised to these kinds of criminal charges based on these facts, but they were mean to me is not one of those legal defenses. Now, it's something the defense attorney can argue and has argued, of course, but it's more of a wish, a hope, than it is a legal defense. But what are the actual legal defenses that could be raised here? Well, one, of course, is self-defense, and self-defense is what's called a perfect legal defense. There's 2 perfect legal defenses possible theoretically here, and by perfect legal defense, we mean a defense that, if believed, would lead to an acquittal, 0 criminal liability, not merely mitigate the offense, but what was done was not a crime under the law. And one of those perfect defenses is self-defense, that he shot Lauren Canarak and at Robert Goodwin because they were presenting as a reasonably perceived imminent deadly force threat in the moment that he shot at them. And by the way, when I say things like imminent, reasonably perceived, deadly force threat, I'm talking about the 5 elements of self-defense, folks. Every self-defense claim is made up of the same 5 elements of self-defense, no matter what jurisdiction you're in. In fact, we have available, and I urge you to download, it's completely free, our 5 elements of self-defense infographic. Man, I have way too many tabs open, but I know I have it here someplace. Let me pull that up. Here we go. This is our 5 elements of self-defense infographic. It lists those 5 elements, provides a brief description of each. We don't charge a penny for this. It's just a free PDF download. If you don't understand these 5 elements, you can't possibly understand self-defense law, use of force law. These are the building blocks, folks. Now, not all 5 are always required. Frequently, 1 or more elements can be waived, but the most is 5. And in New Jersey, none of these are waived. So the most commonly waived element here would be avoidance. Avoidance is whether or not there's a legal duty to retreat before you can defend yourself. There's only 11 states that impose that legal duty to retreat in otherwise lawful cases of self-defense. But New Jersey, where these events took place, is one of them. So in this case, New Jersey is the jurisdiction. All 5 of these elements will apply. If you don't know these elements, I mean, you don't know nothing about use of force law. And again, it's free, folks. Doesn't cost a penny. So I would urge you, if you do nothing else, get nothing else out of today's content, please download that free infographic at lawselfdefense.com/elements. If you happen to be a firearms instructor or someone who would like, for whatever reason, a poster size version of this infographic, we do have that available too. It's not free because we have to print and ship that. But if that's of interest, you can get that at that same URL, lawofselfdefense.com/elements. So those are the elements that are needed to support a claim of self-defense. Now, once a claim of self-defense is raised in court, appropriately raised, so that the court will allow self-defense to be argued, because you don't have an automatic right to argue self-defense in court. I'll circle back to that in a moment. But once self-defense has been raised in court, then the burden of proof on self-defense, the burden of persuasion, who bears the burden of persuading the jury on that issue, the burden of persuasion is on the state to disprove self-defense beyond a reasonable doubt, which is a pretty high threshold. But before you can argue self-defense in court, the defense has to meet what's called its burden of production. There are, as we just said, 5 required elements of self-defense. Before the defense is allowed to argue self-defense at all, before self-defense is permitted before the jury as a legal argument, because that's a role of a court, is to act as a gatekeeper on not just the evidence that's allowed in front of the jury, but the arguments that are allowed in front of a jury. Before the legal argument of self-defense justification is allowed in front of the jury, the defense has to meet its burden of production, which means showing the court that there's more than 0 evidence on each of those 5 elements. Because if any of them has 0 evidence, then it doesn't exist for legal purposes. And if a required element doesn't exist for self-defense, then you don't have self-defense by definition. Now, normally for good guy cases of self-defense, it's not hard to meet your burden of production, and you don't necessarily need to produce it yourself. Often it's in the record from other sources, from other witnesses or surveillance video. But if it's not in there from other sources, then you'd better be prepared to produce it, because if it's not there, you won't be permitted to argue self-defense. Or you'll be permitted to argue self-defense, and the judge will give you the benefit of the doubt that you'll develop your burden of production over the course of the trial. But if you don't, the jury will not get a self-defense jury instruction. And if the jury doesn't have a self-defense jury instruction, they cannot acquit you on the grounds of self-defense. And if they're not allowed to consider self-defense, that's a serious problem, because self-defense is a defense of confession and avoidance. You're confessing to the underlying physical conduct. You're not saying it wasn't me. I have an alibi. I was someplace else. I didn't fire those shots. You're saying it was me. I shot that guy, but I did it with the lawful justification of self-defense. Well, if the justification half of that explanation goes away, what's left except the confession? So because self-defense is a defense of confession and avoidance, you're confessing to the underlying conduct and you're seeking to avoid criminal liability on the grounds of justification. If you lose that justification or can't meet your burden of production, are not even allowed to argue self-defense justification in front of the jury, that's a walk-away conviction for the prosecution. Again, for most good guy cases of self-defense, it's not hard to meet the burden of production. I wouldn't want you to worry about it over much, but this is an unusual case in which the defense may have trouble meeting its burden of production, because the only in-person eyewitnesses to this shooting are Michael Barisone, the defendant who fired the shots, and the victims, Lauren Canarak and Robert Goodwin. And they were subject to direct and cross-examination. And as you might expect, they didn't support a claim of self-defense here in their testimony. There was an ear witness. Lauren Canarak's civil lawyer was on the phone when this went down, but he didn't see anything. All he heard was shots fired. So there was a surveillance camera, but the video was not secured, so we don't have that. Now, often all you need to meet your burden of production is for the defendant himself to say, yes, it was self-defense. I was the innocent victim of a reasonably perceived, unlawful, imminent threat of deadly force, and I had no reasonable means to retreat. That's that duty to retreat that would apply in New Jersey. And if that's the only evidence in support of self-defense, that's enough, because you don't need a lot of evidence in support of self-defense to meet your burden of production. You need more than zero. So if the defendant will give a statement to that effect, well, that's enough. But in this particular case, the defendant says that immediately prior to his firing of the shots, he basically stopped remembering things, and he didn't regain his memory of events until the point at which he woke up in the ambulance after this, because he was beaten by Robert Goodwin and Lauren Canarak. They say after he shot them, and there's no evidence to the contrary. And the evidence can't come from the defendant because he says, I have no recollection. Just before all this happened, Lauren Canarak told me she was going to report me to Child Protective Services for having molested his girlfriend's child. That's what Michael Barisone says. Lauren Canarak told me she was about to report me to Child Protective Services, claiming I had molested my girlfriend's young child. And when I heard that accusation and that threat, I lost my memory. And I didn't regain it until well after the shooting was over. So Michael Barisone has no personal knowledge of what happened. So he can't personally testify to meet his burden of production. So I think there's a very legitimate question here about whether Michael Barisone is going to get a self-defense jury instruction at all. Certainly the ability of the defense to argue self-defense so far throughout this trial has been highly constrained. In their opening argument, for example, the attorney, Edward Blancas, for Michael Barisone, he spoke for about 45 minutes on opening, and about 95% of that was speaking to matters of an insanity defense, premised on how mean the Lauren Canarak and Robert Goodwin were to his client. And maybe 5% of it referenced self-defense, but there's been really no evidence consistent with self-defense introduced in the trial so far. And really very little related to the insanity defense, which is what the testimony we'll be covering in today's live show will be on, the psychiatrist called by the defense. So perfect self-defense is one of the perfect defenses here, but it looks really weak on the ground. The other possible perfect defense here is the insanity defense, which I've already mentioned, but the threshold there is very, very high. The insanity defense is not simply that someone was super angry or made really upset by someone being mean to them. The insanity defense essentially requires that you didn't know what you were doing was wrong. You didn't know you were shooting a human being in the absence of justification. You thought maybe you were shooting a werewolf or a space alien or a robot. And there's no evidence that this event was anything like that. There's no evidence to contradict that Michael Barisone knew he was shooting at a human being. So the prospects for an insanity defense here appear very weak, although we'll see what the psychiatrist has to say. I will note that if Barisone were to be acquitted on the grounds of insanity, he's not simply let free. He has zero criminal liability, but the result would, so he wouldn't go to prison, but the result would be he'd be institutionalized for some indeterminate period until the doctors decided he was safe to release into society. And that could be a relatively short period of time, or it could be never. So that's the insanity defense. But if effective, if bought by the jury, it would lead to, it's a perfect defense because it would lead to a criminal acquittal, no criminal liability. Then there are a couple of mitigating defenses, and one of these is what would be called imperfect defense. Imperfect defense is where you had a genuine subjective good faith belief in the need to act in self-defense, but that belief was objectively unreasonable. A theoretical, reasonable, and prudent person would not have shared that belief. So your belief in the need to use force was irrational. was not objectively reasonable. And objective reasonableness is a required component of self-defense. So if that's missing, if your conduct in self-defense was not objectively reasonable, it can't be self-defense. It can't be the perfect defense of self-defense. It can't lead to an acquittal, but you might qualify for imperfect self-defense. And the result of imperfect self-defense is basically, it says, look, if the only defect in your claim of self-defense was that you had a subjective, genuine good faith belief that was objectively unreasonable, we're not going to acquit you. You don't qualify for self-defense because you're missing objective reasonableness, but we will mitigate what would have been a murder conviction to a manslaughter conviction, or in this case, what would have been an attempted murder conviction to an attempted manslaughter conviction. A manslaughter that's a bad conviction, folks. That's a very serious felony. Could be good for 10 to 20 years, especially since he used the gun. So there'll be a gun sentencing enhancement for sure under New Jersey law. So manslaughter conviction sucks. Unless the alternative is a murder conviction. A murder conviction can commonly be life in prison without possibility of early release. That's forever in a cage. Manslaughter might be 10 to 20 years, but you may be eligible for parole in a third of that time. So you may be looking at 3 to 6 years prison time, and then you're kicked loose. Not great, and felon the rest of your life, but at least it's not forever in a cage. So he might argue imperfect self-defense. Again, there are still the elements that have to be met with a burden of production. So it's not clear to me how he would get there. But if the jury were to buy that, it would mitigate attempted murder to attempted manslaughter, not an acquittal, just a mitigation. And a similar argument could be made for diminished capacity manslaughter on the grounds that what these people, Lauren Canarak and Robert Goodwin, did to this guy was so monstrous. And he was and they knew he was, let's assume, so emotionally and psychiatrically fragile that they knew they would break him. That was their mission. That was their intent. Now, they didn't know they would break him to the point he would shoot them. Maybe they thought he would shoot himself, but he would not have done any of this but for their torture of him. And that torture of him diminished his capacity to reason, diminished his capacity to form the intent required for an intentional murder. And therefore, at worst, we should convict him of basically manslaughter, involuntary manslaughter. Or more accurately, voluntary manslaughter, but a diminishment from murder with the same effect. So he would have a lesser sentence and maybe be eligible for parole in that time. So that's an argument they could make. And, that's supported by some evidence here because Lauren Canarak and Robert Goodwin were not shy about conceding that they were torturing this guy. They admit it. They're not embarrassed about it. So that could go that way, diminished capacity. Then there's the last defense isn't really a defense, it's just a wish. And that is that the jury might conclude that these people, Lauren Canarak and Robert Goodwin, were so vile to Michael Barisone that they just don't want to convict him of anything because they're so sympathetic towards him, or they'll just independently mitigate murder to some lesser included offense. But that's not really a legal argument. That's an emotional argument. So that's where we are in this particular case. Now, again, as always, we're over a couple hundred people now. So I'll remind everybody, if you could please smash that subscribe button. Even if you've done it in the past, YouTube unsubscribes people without telling them. So smash it again. If you want to get notifications, or at least have a chance of getting a notification, do the thing with the bell. So you do that. You may do that and you still don't get notifications. I hear that all the time, but you certainly have no prospect of getting a notification if you don't set the bell appropriately. If you could hit that thumbs up button and leave a comment of any kind, even if it's just your city and state, that helps fool the YouTube algorithm into spreading word of our work product more broadly on the platform. YouTube doesn't like us. I don't know why, but that's just the way it is. So to the extent we can trick the algorithm a little bit, help grow the law self-defense community, that's always appreciated. And as always, if you want to make sure your questions are answered, I would encourage you to either, if you're a law self-defense member, post it on the member dashboard where this live stream should be streaming live there as well. And those questions from the law self-defense membership get the top priority. And then if you're watching on YouTube, put it in super chat form. That's the only way I can kind of pick out those questions from the hundreds or thousands of comments that take place throughout the course of the show. And let me take a quick look over here at our membership page. Yes, and everything is streaming appropriately there. And of course, I guess I shouldn't say of course, but it looks like everything is working fine over at the YouTube stream as well. Not sure about Rumble. Let's see what's going on at Rumble. Rumble is something I still don't have a solid grip on. My content. Take a look at the doctor here. My contents. Yep, and it's working on Rumble. Man, I am getting good at this IT stuff. Rumble, I guess if you do a Rumble rant, I'll take a look at that too before the show expires. Now, before we jump into the psychiatrist testimony, I do want to mention a couple of quick administrative points. One is that today's content is sponsored by CCW Safe, our usual sponsor. CCW Safe is a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay its members legal expenses if the member is involved in a use of force event, and those expenses start big and get bigger fast, folks. Most of the cases I consult on are aggravated assault with a firearm case, and we generally get those charges dismissed or get the person put in a diversion program. So if they keep their nose clean for some certain period of time, the charges get dismissed. Most of those cases we're able to avoid the client having to go to trial. So it's taken care of before trial, and it still costs them in the tens of thousands of dollars. If you've had to kill someone in self-defense and you're facing a charge of murder or manslaughter, it's easy to burn through $200,000 before you ever get to trial, folks. So if you don't have that kind of money stuffed in a mattress, just in case you're compelled to defend yourself or your family against criminal predation, it can be useful to have a financial partner standing behind you to make sure you have the resources you need to fight that legal battle the way you want it fought, as if the rest of your life depended on it, because really it does. And by the way, CCW Safe does more than provide money. They also have their own investigative team. It includes Don West, attorney Don West, their national trial counsel, one of the defense counsel for George Zimmerman. I know Don personally. He's a world-class criminal defense attorney. It includes a team of career homicide detectives who are working for you, not for the prosecutor. All those other homicide detectives are working for the prosecutor. And the CCW Safe team is dropped in at your location immediately to secure exculpatory evidence and witnesses, and to put you in a position where you can most strongly argue for no charges, or if charges are brought, to have those charges dismissed. So I'm a big fan of CCW Safe. I'm personally a member. They're the best fit for me of all the companies that offer this kind of service. My wife, Emily, is also personally a member. Whether they're the best fit for you is something only you can decide. But I do urge you to at least take a look at what they have to offer by pointing your browser to lawofselfdefense.com/CCW Safe. And if you do decide to become a member there, you can get 10% off the first year of your membership using the discount code LOSD10. That's LOSD for Law of Self-Defense, and the number 10 at that URL, lawofselfdefense.com/CCW Safe. And the last thing I want to mention before we jump in, just because it's coming up tomorrow, so we're only about 24 hours away at this point, is our upcoming Law of Self-Defense Hard to Convict webinar. This is a webinar in which we'll engage in myth busting. We'll be busting some of the most common myths about use of force law, the kind of things that are very commonly believed. I see it endlessly throughout my 30-plus year career, focusing my legal practice on use of force law. These are myths that are shared on the internet, on gun magazines, gun forums, by, unfortunately, too many self-defense instructors, by the retired cop neighbor down the street, by the lawyer who did your house closing. Lots of people believe these myths of self-defense law, and they're the kind of thing that, if they're believed and followed through on, set you up for a conviction and a lengthy, decades-long prison sentence. They make you easy to convict, which is not what any of us want. We want you to be hard to convict, not by knowing legal tricks, but by knowing what the law actually is and not believing these myths of self-defense law. So that's the purpose of our Hard to Convict webinar, is to bust these myths, help make you hard to convict, transform you from easy to convict to hard to convict. And we'll also do an extensive Q&A. And the webinar is somewhere between an hour and 2 hours long. We'll see how it goes. But it's 100% free, folks. We're not charging a penny for this. The first of these, we're doing a series of them over the month of April. They're all the same, so please only sign up for whichever date or time is most convenient for you. The first of these is tomorrow, April 6th, Wednesday, April 6th at, I believe it's 2 p.m. Eastern time. And there are limited seats. Frankly, that one might be sold out. So if you go to sign up and you don't see it listed anymore, it's because it's sold out. I know we only had a few seats left. We're somewhere at 75% of all the seats are taken. I would say sold out, except we're not selling the seats. They're free. But something like 75% plus of all the seats are already taken. So if you're interested in participating in one of these hard to convict webinars, I urge you to point your browser sooner rather than later to lawofselfdefense.com/hard to convict before all those seats are gone. All right. So before the last step, before I jump in, is of course, we like to take care of all our super chat folks. Also our Law of Self-Defense members vote. So Beth, a Law of Self-Defense member, is in her membership dashboard watching this. David, as usual, is there. Thank you, David, for being such a reliable supporter on our live broadcast. David mentions the video appears to be zooming in and out slightly. I don't see that on my end. Zach Weber says he's reselling them. Okay, well, we'll see, Zach. If you have that many sock accounts, I guess we'll see what happens. Or there may be alternatives. Alternatives that we can take to deal with this kind of situation. Let's see. It turns out there is. Okay, so let me close the lawofselfdefense.com/hard to convict window so you see me in all my glory. The Law of Self-Defense members, David says the video's fixed itself. Great. Let's take a look at our super chats. Go there, go here. See if anything's come in yet this morning. William Andrews, thanks for your super chat contribution. He writes, Tim Pool was talking about Kyle Carruth last night. I think he tried to speak carefully, but still made an emotional or philosophical argument rather than a legal one. Kyle Carruth, this was the shooting in Texas where Kyle Carruth shot Chad Reed. I did a blog post on it just a couple of days ago. And then I did a much more extensive legal analysis of the event right after it occurred back in November. If you're a Law of Self-Defense member, you can probably dig that up over at our blog, lawofselfdefense.com/blog. Of course, any of these cases could always go either way. There's always arguments on either side. But there definitely was an argument to be made here that this shooting was not legally justified, that at the moment that Kyle Carruth shot Chad Reed was standing 10 or 12 feet away, unarmed, not advancing, not doing anything that would present in that moment as a threat of deadly force harm towards Kyle Carruth. That was my reading of that evidence, and it was captured on video. But obviously there was a lot of emotion involved in this case. It was Kyle Carruth's house. Kyle Carruth had been thrown off his porch. Kyle Carruth was dealing with a jackass. And Kyle Carruth himself was everybody, all the adults involved, and there was a child custody issue in this case as well. So all the adults were pretty much acting like jackasses. Really, none of this had to happen. The shooting didn't have to happen. The death didn't have to happen. But in any case, the matter was put before a Texas grand jury, and the grand jury late last week declined to return an indictment on Kyle Carruth. So that's effectively the end of the matter. My only cautionary note is don't conclude from that this was automatically or inherently lawful, or that a narrative of guilt could not have been spun by a prosecutor. What the grand jury does is largely a result of what the prosecutor wants. If the prosecutor wants an indictment, he'll get an indictment. And if he doesn't want one, he won't get one. So I presume here the grand jury returned a no true bill, no indictment, because the prosecutor didn't want an indictment. The grand jury only hears one side of the story, folks. They only hear the prosecution side of the story. So if they heard the story and came back no true bill, well, that's because that's the story the prosecution told them. But a different prosecutor in a different jurisdiction, even with the same facts, the same prosecutor in the same jurisdiction on a different day with the same facts could easily have spun a narrative of guilt and gotten an indictment and dragged Kyle Carruth off the trial. And once you're in trial, the risk of conviction is never zero, folks. It's always greater than zero, even if you're actually 100% innocent. So don't presume that there's no legal liability involved in this Kyle Carruth event. Unfortunately, I think too many people do that. They look at a legal outcome of a real world case and they presume from that legal outcome that that must be the outcome that had to happen. And there's a phrase for that, folks. It's called outcome bias. It's like, you roll a 7 in Las Vegas at the roulette table and you think, well, that must have been fated. In fact, if I roll again, I'll get another 7 because that's the kind of outcome I get. It's what's called a logical fallacy. It's not a rational means of thinking. But most human beings are not rational. We're not actually wired to be rational. We have to be trained to be rational for the most part. And most people are not trained to be rational. That's why you find these politicized or emotionalized, really two sides of the same coin. Politics and emotion are really not different. Interpretations of these events, by the way, including this trial, the Michael Barisone trial. Lots of people are fully in favor of Michael Barisone shooting Lauren Kanarek and shooting at Robert Goodwin because Lauren Kanarek and Robert Goodwin appear to be monsters the way they treated him. But that's not a legal argument. That's an emotional argument. For a legal argument, you have to look at the law, and the law does not entitle you to shoot people because they're mean to you. But that's the norm. And of course, Tim's not a lawyer, not trained as a lawyer. He's trained as a fundraiser and a journalist. And those are, there's nothing wrong with either of those by any means. But being highly rational is not required for either of those. In fact, being very effective at a kind of emotional intelligence is probably what makes for the most compelling fundraiser and the most compelling journalist. And so it doesn't surprise me that Tim's view of the case is that. And again, it doesn't make Tim a bad person. I like Tim a lot. I've been on his show several times. But that's the norm. We shouldn't expect people to be coldly rational as a matter of course, because we will be sorely disappointed throughout our lives. I mean, it's one of the reasons I went into the law is by nature, I tend to be rational. And inside a courtroom where we have very rigid rules about what kind of arguments and evidence can be presented and considered, it's being highly rational can be advantageous. Out in the real world, being highly rational, folks, even just being right by itself is highly overrated. If you're right all the time and everyone else is wrong, you're going to have a rough life, man, at least socially speaking. You'd think that wouldn't be the case, but my personal experience is being right all the time when everyone else is wrong is not the way to go through life. Believe it or not. Humans are social animals, and that's not a socially productive means of traveling through life. Okay, let me take one last look at the super chats here. Make sure we don't have anything else, and then I'll jump into the psychiatrist testimony. Okay, good. So now, now I'm going to take a moment to close a bunch. I have like 800 tabs open, and it's making it more difficult for me to select the tabs I really need here. So that can go. Super chat, I'll keep. Me streaming, I'll keep. Zach Weber can be deleted. Because this is my house, folks. And if you act like a jerk inside my house, I reserve the right to block you. That's just the way that goes. If you have your own house and you don't like the way I act there and you'd like to block me there, that's totally fine. Okay, let's see. Close a bunch of these tabs. Click, 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 click. Clean up my streaming interface a bit. By the way, I presume we've all heard the news that Elon Musk bought a whoops, almost closed out the live stream by accident, folks. That would have been nasty. Elon Musk bought almost 10% of Twitter. And apparently, because the stock price of Twitter skyrocketed after that, he's already made almost $1 billion profit on the purchase, roughly double what Twitter itself as a corporate entity has made in profit over the last several years, which is, irony can be delicious for sure. All right, almost done here, folks. Oh, I did want to touch upon one other thing, just in passing, because I saw this. So there's an online news website called The Hill. You may be familiar with it, you may not. And they did an article recently on Kyle Rittenhouse because Kyle Rittenhouse's rifle was recently destroyed. It was fed into a rifle chipper. And so The Hill wrote a story about that. And in their story, they report that in January, Kyle Rittenhouse had asked for his rifle back. But then in February, he said, well, it's okay if the court destroys it. Why did it, like he changed his mind? Like there was something wrong with him in January. He wanted it back. And they never say that explicitly, but that's the implication. In January, he wanted that rifle handed back to him. In February, he said, well, he would allow the court to destroy it. So it suggests there's something wrong with Kyle Rittenhouse. In fact, the only reason Kyle Rittenhouse wanted the rifle given to him was to destroy it, which is what he said at the time. So there was no change of mind here by Kyle Rittenhouse. The goal was destruction of the rifle. But I just raised that because it's another example of how the media lies always at every opportunity, if not explicitly, then implicitly, like in that particular news story. All right, so let's pull up the psychiatrist testimony. Come on, man. Let's see. Here it is. Rewind it a little bit. That's gonna get back to his being brought in initially. Okay, he's stepping up there to be sworn in, or maybe he's just been sworn in. And his name is Dr. John Bascara. Now, I believe it or not, that his testimony only lasts for a few minutes. We'll see. But that would be rather shocking given that, the perfect defense of self-defense appears to have no meat to it here. The only other perfect defense here would be the insanity defense, and this would be the guy to nail it. If this guy doesn't nail insanity defense, there will be no other testimony that can do that. And I doubt he does it in 10 or 15 minutes, but let's see what happens. And here we go. Yeah, I'll try to, I have the plugin that Nick Ricada suggested to me. It doesn't seem to do all that much, to tell you the truth, but it's cranked up to 600%. I'll crank up my soundboard as much as I can, and we'll see. We'll have to see what happens. All right, here we go, folks.
Your right hand, you can put your pad and notes down. That's it. Raise your right hand. My clerk will administer an oath.
Do you swear in the presence of Almighty God that the testimony given to this court regarding this matter shall be the truth, the whole truth, and nothing but the truth?
Yeah.
Please state your name and spell your last name for the record.
Yeah, John Daniel Bascara, Bascara.
Boy, that is really bad, isn't it?
Please keep your voice up nice and loud.
Yeah.
The microphone only records, it does not project your voice.
Okay.
All right. And if you don't understand.
Can you imagine running a courtroom in the modern era, knowing it's being televised and giving your witnesses a microphone that only records but does not amplify their voice? It's only going to a recorder someplace. Absolutely incredible.
Standard question, please indicate that. I'll have counsel rephrase.
By the way, folks, if you don't like the way I do this content, don't let the door hit you in the ass on the way out. It won't bother me if you're not here bitching and moaning in the comments. So, I mean, I don't know what's wrong with you, why that you would stay here if you don't like it here.
Go ahead, Mr. Blancas.
Good morning, Doctor. Where are you employed, sir?
Morris County Correctional Facility.
In what capacity?
I'm the jail psychiatrist.
And how long have you been in jail psychiatrist?
Since January 2016.
Now, can you give the jury a little bit of your background, your education and experience prior to August 2019?
Yes, I completed my
Well, that is terrible. I can hardly hear it at all.
psychiatry training in 2004 at Thomas Jefferson University. And in 2006, I finished my child and adolescent psychiatry training at New
Hopefully
Jersey
that's
Medical
better.
School here.
Directing your attention to August 20th, 2019, did you have an occasion to talk to my client, Michael Barisone?
Yes.
And what was the purpose of that discussion?
Oh, it was, I was referred by the staff because this guy by referred to me. Yeah, he had been complaining of stuff.
Yes. Did you offer a report, doctor,
Oh,
based on your
Yes, I
interaction
did,
with the
yes.
defendant?
Yes.
And was that done around the same time,
Yes, yes.
contemporaneously with your interactions with the defendant?
After I saw him.
Yes. All right. And do you need that to refresh your recollection about specifics of your interaction with the defendant?
Yes, I have
All
a
right.
copy or two.
Okay, all right, we're gonna have that. Is it been marked, Mr. Blancas?
Hey, thanks for mentioning the echo, whoever that was. That should be taken care of now. Sorry about that.
Just for reference, for the record. What's the exhibit number?
600-6.
Oh, okay, that's the same. Okay. Okay.
Doctor, as a psychiatrist, did you ask Michael Barisone about the events that occurred on August 7th, 2019?
So we haven't missed anything, folks. Everything that was prior when the audio was bad was his kind of background and credentials and introducing the exhibit, the report that he would that was the result of his speaking with Michael Barisone. So I apologize for that poor audio up front, but it should we shouldn't have missed anything substantive. They're only getting into the substantive content now. So this is the defense attorney Edward Blancas asking his expert witness, Dr. John Bascara, the psychiatrist, whether or not he spoke to the defendant, Michael Barisone, which obviously he did. And we'll hear some of those findings now. What we're looking for, folks, is insanity defense material. So was there something? Did this doctor conclude that Michael Barisone did not know he was shooting another human being at the time he shot Lauren Kanarek twice in the chest and shot at Robert Goodwin? Did he think he was shooting a Martian or a werewolf or a robot? That's what we need to see from this testimony for it to support an insanity defense.
Yes.
Was he able to remember or respond to your questions regarding the actual event?
He told me that he couldn't recall what happened. So,
No further questions.
What?
Mr. Schellhorn, any cross?
Dr. Bascara, can you describe the nature of your
What? What? That was it? I was only half listening. I was waiting for them to get to some meat. Okay, folks, it was so short. I'm actually going to rewind it and do it again. All right, here we go.
Your voice in the
Oh,
courtroom.
okay.
All right, and if you don't understand it,
That was like 3 minutes. All right, so I just rewound it. We're going to do it again, folks.
question, please indicate that. I'll have counsel rephrase. Go ahead, Mr. Blancas.
Good morning, doctor. Where are you employed, sir?
Morris County Correctional Facility.
In what capacity?
I'm the jail psychiatrist
And how long have you been in jail psychiatrist?
since January 2016.
Now, can you give the jury a little bit of your background, your education and experience prior to August 2019?
Yes, I completed my psychiatry training in 2004 at Thomas Jefferson University. And in 2006, I finished my child and adolescent psychiatry training at New Jersey Medical School here.
Directing your attention to August 20th, 2019, did you have an occasion to talk to my client, Michael Barisone?
Yes.
And what was the purpose of that discussion?
Oh, it was, I was referred by the staff because It's okay if I refer to my notes. Yeah, he had been complaining of.
Yes.
So-
Did you author a report, doctor,
Oh,
based on your
Yes, I
interactions
did,
with the
yes.
defendant?
Yes,
All right.
yes,
And was that done around the same time,
Yes, yes.
contemporaneously with your interactions with the defendant?
after I saw him.
Yes. All right. And do you need that to refresh your recollection about specifics of your interaction with the defendant?
Yes, I have
All
a
right.
copy. Or do you-
Okay, all right, we're gonna have that. Has it been marked, Mr. Blancas? Just for reference, for the record? What's the exhibit number?
600-6.
Oh, okay, that's the same. Okay. Okay.
And Dr., as a psychiatrist, did you ask Michael Barisone about the events that occurred on August 7th, 2019?
Yes.
Was he able to remember or respond to your questions regarding the actual event?
He told me that he couldn't recall what happened. So,
Oh,
No further questions.
oh my gosh. That was it.
Mr. Schellhorn, any cross?
Dr.
That was
Bascara,
it.
Can you describe the nature of your examination? Was it a forensic examination?
no.
Was it a clinical examination?
Yes.
And how did you gather the information that you needed to treat Michael Barisone on August 20th?
We just met in the examination room, and as based on his self-report, the interview.
And based on your conversations with him, did you note any delusions with his thinking?
No.
Did he mention anything during the course of the interview with you about being fearful or scared?
Yeah, let me just refer to.
You have to refer to the report for that. Come on, Doc. You knew you were coming to testify.
He just said that he had been very nervous. His mind was racing. That's what I was. Yes.
Did you note in your report that he was acting apparently impulsively with this recent violent behavior?
Well, that's also based on the report, just of what he told me, what happened.
Right. So you wrote that based on what he told you.
Yes.
You indicated that he had apparently acted impulsively and violently.
Oh, did I put that in my? Yes.
Where it says diagnosis,
Yeah.
what does that mean where it says rule out amnesia due to head trauma?
Oh, no.
No, it's just because one of the two complaints, one was anxiety, the other one was forgetfulness. So I just a possible explanation of what he's saying.
No further questions, Judge.
Any redirect, Mr. Blancas?
No, Judge.
All right, you may step down.
Oh my God. That was that was awful. I don't believe there is another psychiatrist, folks. I think this was the psychiatrist. This is a defense witness. I know the psychiatrist works for the state. He works for the prison system. I believe this is the only psychiatrist. I do see, I just took a quick peek, that there is a psychologist also called by the defense. So I'm going to fast forward to the psychologist in just a moment so we can watch that testimony. But this did absolutely nothing for the defense here. There was no evidence in support of an insanity defense at all. And if anything, they undermined a self-defense narrative, because again, now we have more evidence in the record in front of the jury that this defendant doesn't recall anything about what happened. So even his own testimony cannot be used to meet his burden of production on self-defense. That's not good, folks. And if there's nothing for the state to counter argue, well, there's no burden on them in disproving self-defense beyond a reasonable doubt. Keep in mind, to win against self-defense, the state does not have to disprove self-defense in its entirety. It merely needs to disprove self-defense beyond any reasonable doubt. any one of these elements beyond a reasonable doubt, or prove that there's zero evidence in support of any one required element. And it appears to me that there is a number of elements with zero evidence to support them, so that there effectively is no claim of self-defense. So there is no burden on the prosecution to disprove self-defense. Again, it would not surprise me if this jury does not get a self-defense jury instruction. Now, judges generally don't like to do that. If there's even a scent of a claim of self-defense, they usually will give the instruction because they're always worried that the Court of Appeals will reverse the conviction on the grounds that an instruction was not given if there was any basis, in fact, to support it. But man, it's beginning to look like such a clear-cut case of a failure to meet the defense's burden of production on self-defense that declining to give an instruction on self-defense would be justified. So, yeah, I mean, and certainly the defense didn't do anything for itself with this defense counsel. I don't know what the point of all that was. They did not have to call the psychiatrist. It's not like the state called the psychiatrist. I don't know why the state didn't call the psychiatrist. I don't think they did. But if I were the state, I would have called the psychiatrist just so the psychiatrist could testify that the defendant said he has no memory of what happened. Amazing. All right. Well, that is a little bit, that was a little bit disturbing. Yeah, Barisone does have a new shirt and tie today. That's true. I appreciate that. Yeah, I know my computer gets reflected in that the picture behind me of that's a print of Washington crossing the Delaware. There's nothing on my computer that is privileged or I'm too concerned about. In any case, yeah, I really do need to get a piece of non-reflective glass in that picture or move it, but I kind of like it back there, so we'll see. All right, super chats. Let's see if there's anything here I need to take a look at. That was really kind of a train wreck of psychiatric testimony for the defense there. All right, so the next kind of mental insanity defense possible witness would be Sean Cullen. That's a psychologist called by the defense. All the other witnesses called by the defense really appear to be friends of the defendant, dressage athletes, people who knew him, friends, attorneys of the defendant, people who are going to say nice things about him, but none of them were witnesses to the events, so they can't actually testify to the events, and therefore can't testify to any of the elements of self-defense here. But let me fast forward if I can. Let's see, 1, 2, 3, should be the fourth witness from now. So let's see, that was the psychiatrist. 1, that's a police officer. 2, a female. 3, another female. I'm looking for Sean Cullen. This must be Sean Cullen.
No redirect, Your Honor.
All right, you may step down, ma'am. Thank you.
Oh, sorry, Ms. Brock.
So hopefully this is Sean Cullen now.
All right, next witness.
Sean Cullen.
So he's a
Sean Cullen,
psychologist.
please, to the stand.
Let's see if he has anything favorable to say in support of an insanity defense here.
Walk up the table right there.
Hi, Mr. Cullen. Place your left hand on the Bible, please. Raise your right hand. Please listen to the oath.
Do you swear in the presence of Almighty God that the testimony you give to this court regarding this matter shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Please state your name and spell your last name for the record.
Sure. Full name is Sean Cullen. Last name is Cullen.
Thank you.
Thank
All
you.
right, you may have a seat, Mr. Cullen. Please keep your voice up nice and loud. You can remove your mask if you want to. I leave that entirely up to you. But if you keep your mask on, you're going to have to speak that much louder so we have jurors in the first 2 rows.
Sure, I'll pop off for you.
Okay, all right, very good. Thank you,
Don't mind
Mr.
my
Cullen.
nose.
No, not at all. All right, Mr. Cullen has been sworn. Go ahead, sir.
Oh my, is that a relation of Nick?
Mr. Cullen, where are you employed?
Atlantic Health Systems.
And can you give the jury a little bit of your background?
Sure. I'm a licensed professional counselor within the state of New
I've
Jersey.
never
My
been in
degree is
military
in
service, folks,
Masters
but I have
in
lots of
Counseling
friends who
Psychology.
have been. And those glasses
worked
look a
in
lot like
behavioral
those
health
glasses
for
the
just a
Marine
little
Corps
over 20
gives you in
years now.
boot camp.
And I have an extensive history of doing psych evals interviews in ER settings.
And where did you go to school?
Caldwell University.
Now, directing your attention to August 9th, did you have an occasion to meet and talk with my client, Michael Barisone?
Yes.
And at any point in time, did you try to ask him specific questions regarding the event in question?
So again, folks, we're looking for insanity defense evidence. Evidence that this defendant, Michael Barisone, didn't know he was shooting people. He thought he was shooting space aliens, werewolves, robots. That's what we're looking for here. That's what would support the insanity defense. There's nothing this guy can really say that would support self-defense. He wasn't there.
Specific questions, no. Not about the event.
Okay.
What?
Did he make any statements with
What?
regards to these specific?
What?
Did you have an occasion to meet and talk with my client, Michael Barisone?
Yes.
And at any point in time, did you try to ask him specific questions regarding the event in question?
Specific questions, no. Not about the event.
Okay.
All right. Well, that would suggest it's going to be difficult to come up with any kind of testimony from this guy about whether or not Michael Barisone thought he was shooting a Martian if he didn't ask him any questions about the event. Huh.
Did he make any statements with regards to the specific event?
Yes.
What did he say?
He spoke, as was cited in my documentation, he spoke about the stressors of the event, some aspects in the days before the event. To my recollection and what's in my documentation, he did not recall the immediate events that result in his being in the hospital.
Nothing further.
Oh,
Cross-examination.
oh my God.
Thank you, Judge. Mr. Cullen, when you met with the defendant on August 9th of 2019.
All right. So obviously there's no insanity defense evidence in that psychologist testimony at all. I guess there is suggestions about the fact that he was being treated poorly, vilely by Lauren Canarak and Robert Goodwin. I suppose that could go to, I mean, I don't even see imperfect self-defense being on the table here anymore, but I suppose it could go to a diminished capacity defense where the torturous treatment stripped him of the capacity to form the intent necessary for murder. So at worst, you can find him guilty of attempted murder, or it could go towards the wish defense. You know, these people are so vile. You should have sympathy for my client. And if not for legal reasons, for sympathy reasons, find him guilty of some lesser included offense than attempted murder. But this 3 minutes or so of direct questioning of the psychologist didn't get any more than that for sure. And I would suggest not that much.
Did he indicate to you that he had told the police that things at his farm were going to come to a boiling point?
I believe that was a quote in my documentation from that day, from that interview with him.
And Judge, if I could just approach briefly.
With his report?
Yes, Your Honor.
All right, what's the marking
I
on it?
marked it as S84, pages 35 and 37 of S84.
Mr. Cullen, that report is just to refresh your recollection at this point. Just take a look at it. Tell us if you recognize what that document is.
Yes, Your Honor.
Is that a report that you authored?
That is correct.
Do you recall the date you authored the report?
Yes.
And does that, in essence, summarize your interactions with Mr. Barisone on August 9th?
Yes.
Thank you. Go ahead.
And Mr. Cullen, directing your attention, I believe it's about a quarter of the way or a third of the way down that first page. Did you put that, excuse me, probably a little bit further down the page than that. Did you put that in quotation marks that this was going to come to a boiling point?
Judge, I object. I ask that he read the entire sentence. It's out of context.
Again, just object, Mr. Blancas.
I don't like counsel editorializing.
Yeah, so like most judges, this judge doesn't like speaking objections. Speaking objections are very popular in the movies and TV because they add drama to the proceedings. But for that same reason, judges don't like them. Just object. If the judge asks you what is the basis for your objection, you give a 1 or 2 word response sufficient to inform the judge on what you think the grounds for objection are. And if the judge needs more explanation or debate on the issue, he'll invite the lawyers up to the bench to have a sidebar to discuss it. What they don't like is for lawyers to object and then provide some lengthy explanation or narrative behind their objection, because that's all being heard by the jury, and it could be biasing the jury in a manner that is inappropriate. If the objection is overruled, for example, if the objection turns out to have no merit, then all that explanation that the jury heard also has no merit, but the jury doesn't know that, and now the judge has to give some kind of corrective instruction. Please don't pay attention to all those words the lawyer said, which obviously is rather pointless. So that's what the judge was objecting to here. So another sidebar. I don't know if this trial has the record for sidebars, but there sure have been a ton of them, at least in the witnesses that I've seen. Yeah, that's another funny part of all this is during the state's case in chief, on cross-examination, the defense was constantly cherry-picking remarks out of written documents, reciting statements out of context and being called on it, not just by the state, but by the judge. And it happened, it seems, with almost every witness. Certainly it happened with the cross-examination of Lauren Kanarak and Robert Goodwin, for sure. And every time he was called on it, the defense was called on reading stuff out of context. It turned out he was, in fact, reading stuff out of context. Now, having done that relentlessly himself, he objects at the slightest hint of out of context testimony by the state prosecutor. It's somewhat ironic. Just going to see how far this. Sometimes these sidebars are fairly lengthy. This one looks like it's pretty short. Okay, I think we'll start up again in just a moment. Look at that line on his nose. I wonder if that's from the mask. Here we go.
Mr. Cullen, I think the question I asked you was if you could read the direct quote that Michael Barisone told you from your report, if that refreshes your memory.
Certainly. The direct quote in quotations is, I kept telling him this was going to come to a boiling point.
Now, didn't he also tell you on that day that his significant other didn't feel safe?
That is correct. That's also in the documentation. There's a quote for that as well.
He never told you anything about he himself not feeling safe.
To the best of my recollection, that was not quoted directly to me.
Did he also tell you?
So that's relevant because, let's assume he's saying the truth, that he thought his girlfriend, Michael Barisone, thought his girlfriend, who lived with him on the horse farm with her son, I believe it's a son, with her child, by another male, baby daddy. If Michael Barisone had genuinely believed that Lauren Kanarak and Robert Goodwin were a threat to his girlfriend, and his girlfriend had been at the scene, perhaps he could argue that his shooting of Kanarak and Goodwin was in defense of his girlfriend. But his girlfriend was not on the scene. So any theoretical, speculative threat against his girlfriend could not have been the driver, the lawful driver behind his use of deadly defensive force against Kanarak and Goodwin. And he himself was not saying, I believed I was in danger of them in his discussion with the psychologist.
Tell you that around the time of the shooting that DCP&P or Child Protection was at the property?
Yes, according to my documentation, it was noted to be the morning prior. the DCP&P were present.
And did he tell you that there was a specific reason that DCP was there?
So this DCP, for folks not in New Jersey, that's their version of Child Protective Services. Different states have different names for such a thing. But these people were called at the behest of Lauren Kanarek and Robert Goodwin. I mean, this was part of their torture of Michael Barisone to suggest that his girlfriend's child was either unsafe or directly threatened by Michael Barisone himself. That's one of the things that finally apparently appear to have driven Michael Barisone completely over the edge, to the point where he, after hearing that accusation, he lost his ability to recall events.
Was for a call pertaining to the care of his girlfriend's children.
To the best of my recollection, he mentioned that he felt that someone had called them, making possible accusations, so they arrived due to concerns to investigate.
Did you note that he said to you a number of times that there was a steady building of stressors in his life?
Yes, that is noted in my documentation.
And I believe if I refer you to page 3, did you indicate that he noted several acute stressors in the 48 hours preceding his admission to the hospital?
Yes, that is correct.
But he didn't specifically note that fear was one of those stressors?
Not specifically in my recollection, not that I quoted in the report.
Last question, Mr. Cullen. You found Mr. Barisone's thought content to be unremarkable for delusional distortions?
That is correct.
Judge, no further questions. Thank you.
All right, any redirect?
Yes, good. With regard to the quote that the prosecutor read you regarding, I kept telling them this was going to come to a boiling point.
Okay, so this is the quote that this lawyer said the prosecution had elicited out of context. They had a objection, they had a sidebar, and as is most frequently the case in this trial, the state won at sidebar. Obviously, he was not required to expand on the context. Obviously, what the judge told the parties was, hey, you're going to have a chance to redirect. On redirect, you can add the context. So let's see how out of context that quote actually was. I'll rewind it just for a moment so we can hear the quote again, and then we'll see how out of context this defense can show that to have been.
Thought content to be unremarkable for delusional distortions?
That is correct.
Judge, no further questions. Thank you.
All right, any redirect?
Yes, good. With regard to the quote that the prosecutor read you regarding, I kept telling them this was going to come to a boiling point. Who did he indicate to you that he was telling this to several times?
The local police department.
Does that change the context? I don't think that changes the context.
Were you given information that he possibly had PTSD?
PTSD is listed in quotes in the documentation. For the service I work on, the psychiatric consult service, when a physician puts in a consult order, they always put a rationale for that order. That was the initial rationale by the medical team.
And did they also indicate that there was a complaint of loss of consciousness?
That was also, it's quoted in my documentation. That comes from the medical notes.
With multiple trauma status, correct?
That is correct.
Is there any notes with regards to a left elbow dislocation?
Judge, I'm going to object that this is beyond the scope of the cross-examination.
So for those who may not know, Michael Barisone was subject to a beatdown by Robert Goodwin. Also, I think Lauren Kanarek, who smacked him with her phone, something to that effect. But he did suffer pretty substantial injuries at the hands of Robert Goodwin. He was punched in the face repeatedly, the face and head. He was put in a chokehold. His arm was twisted back enough far sufficiently to damage his elbow. But of course, Goodwin and Kanarek say all that was done after he shot them or shot at them, and it was force used against Barisone in self-defense. It didn't precede the shooting. It wasn't a justification for Barisone shooting them. It was done in defense by them after the shooting so he wouldn't shoot them again. So unless the defense has evidence to reverse that time sequence, all this testimony about the physical injuries to Barisone are innocently explained.
It is somewhat
The details of the report.
I'm sorry?
Prosecutors got into the details of the report, which I did not on direct, and now I believe I can bring out other details based on his cross.
All right, I'll allow it. Overruled.
Did it indicate that there was multiple traumas to Michael Barisone?
Per my documentation, the medical documentation, yes.
Open reduction, left elbow dislocation, correct?
That is correct. That's from the medical documentation.
Nothing further.
Anything further, Mr. Shellhorn?
No, Your Honor,
All
thank
right,
you.
Mr. Cullen, you may step down. Thank you. Let's watch your step, please.
All right, and that's it. Quick psychologist. Nothing to support an insanity defense there at all. Nothing absent evidence of change in sequence of events from the victim testimony that could have justified this shooting as self-defense. For the people who can't imagine how Lauren Kanarek could have smacked Barisone with her phone after being shot twice, people fight after being shot all the time, folks. These were obviously not debilitating wounds. She was still standing up after she was shot for some time. So it's not at all uncommon. The most common response to people shot with a handgun, or a very common response, is, "I can't believe you shot me." It's not
Jordan
immediately
Osborne,
disabling
please.
unless it hits very specific areas of the body. Even then. I mean, you know, those of you familiar with the 1986 Miami shootout with the FBI know that the FBI shot one of those aggressors in the heart with a 9mm round. And that guy with a bullet in his heart went on to kill several FBI agents in that fight. So people can still fight after being shot. Just look at this poor guy.
Place your left hand on the Bible, please. Raise your right hand. Please listen.
Well,
to the
I may
oath.
have to listen to this testimony
Please, when the
just
presence of
because,
Almighty God, that the testimony you give to
if
this
you know what I
court regarding
mean,
this matter shall be the
and I
truth,
think
the
you
whole
do.
truth, and nothing but the truth.
Yes, I do.
Please state your name and spell your last name for the record.
Jordan Osborne, Osborne.
Thank you.
All right, Ms. Osborne, you can have a seat. Please keep your voice
I
up
wonder if
nice and
this is the
loud.
girlfriend's child.
That microphone does not project your voice in the courtroom. It just records it. So
I believe
the
she
jurors in
lived
the
on
first
the
two
farm.
rows and in the jury box have to hear your natural voice. All right?
Yeah.
Thank you. If you don't understand a question, please indicate that and I'll have counsel rephrase. All right.
Good
Witness is
morning, Ms.
sworn.
Osborne. How are you?
I'm good. How are you?
I'm well, thank you for asking. As of August 2019, how old were you?
I was 16.
You were 16 years old, and
So this is the first time I see in the comments that this co-counsel, second chair for the defense, asked some questions of witnesses earlier today. I didn't see any of that. This is the first time I'm watching this guy at work. Let's hope he's better than is Edward Blancas. I mean, I'm not sure how much he has to work with here, but it's possible to not have a lot to work with and still be competent. You don't have to be incompetent just because the facts of your case suck.
did you live at the farm in Long Valley where Michael Barisone operated his business?
Yes, I did.
And what did you do there? Just in general, that summer?
I was a working student, so I rode and I helped take care of the horses.
And so give us an idea of what your daily regime was in life back in those days.
We'd get up and we'd feed the horses breakfast, and then by then it was time for everyone to ride. So we'd help get horses ready. We'd ride our own horses. We'd feed lunch, keep riding, feed dinner, and then just normal, regular barn chores, cleaning things up.
Were there other students living there as well?
Yes.
And who were they?
There was Chelsea Westra and Mike McGrain and Cassandra DeFranco. And then Justin was there as the assistant trainer.
And was Cassandra a student, or did she have some other capacity there?
She was a barn manager. So with everything, taking care of the barn and the horses, she was in charge of that.
And were you aware that there were other people living at the farm in the farmhouse in the summer of 2019?
Yes, I was.
Who were they?
Lauren Canarak and Rob Goodwin.
And did you interact with them at all on a regular basis?
Yes, I did.
Your Honor, request to approach the witness.
Sure.
I'd like to show you a photo which has been marked as D800-90. Do you see the photo?
Yes,
Who's it a photo of?
that's Rob Goodwin.
And does this photo depict Goodwin's appearance as you understood it to be back in August of 2019?
Yes.
Your Honor, I move 800-90 in evidence.
Objection.
So one reason the lawyers tend to ask that kind of question, here's a picture of one of the participants. Does it reflect what he looked like at the time? Is because sometimes the pictures don't reflect what the person looked like at the time. In the George Zimmerman trial, for example, just before George Zimmerman's being targeted by Trayvon Martin in Florida, George Zimmerman had, in the months preceding that, been on a fitness regimen. He had lost a ton of weight. He was thin for him. He was not a big dude. But between that event in which he ended up successfully defending himself against Trayvon Martin, shooting Trayvon Martin dead, and then being dragged to trial on ridiculous second-degree murder charges, that took 14 months from shooting to the end of that trial. During that period, as you can imagine, under all that stress, Zimmerman went back to his unfitness practices, and he ballooned. He gained a ton of weight. So when he appeared at defense table during the trial, he looked huge. And that was deceptive to the jury because that's not what the guy looked like when he was in the fight with Trayvon Martin. So I can tell you, having talked to his attorneys about it, it was a real concern for them. They were very, very unhappy about that. But of course, there was nothing they could do about it.
I'm not sure what the relevance.
Another sidebar. Oh, look, the judge calls up. The judge finger there. So I guess the prosecution doesn't know where they're going with this showing of the photos of Robert Goodwin. I mean, the jury knows what Robert Goodwin looks like. They've seen him testify. Blah, 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 blah. I'm just flipping through the comments here. Folks, if I had $1 for every time someone called me a racist, I would have a lot of dollars. I would have a mountain of dollars. It's just what people who are cognitively limited fall back onto when they don't have an actual argument to make. It's fine. I don't take it personally. Yeah, I mean, this does highlight one of the dangers of having people move onto your property. It's almost impossible to get rid of them. And if they turn out to be toxic and vile and malicious, those are not grounds for getting someone off your property if you've let them live there. Once they live there, they're tenants and they have rights under the law as tenants. And it can be months before you can get rid of them. And maybe not even then. I covered the Zimmerman trial, folks. I covered every second of the trial proceedings and most of the pretrial proceedings back when it happened in 2012. And I'm not doing all that again. But I believe if you point your browser to lawofselfdefense.com/Zimmerman, you can see all my coverage of that aggregated on that page. And for people asking about someone asked in the comments about the Burlington Coat Factory shooting that happened some months ago. I covered that at the time, folks. I did a legal analysis. So the Law of Self-Defense members got that. I'm not going back to do it again. I've already done it. The same with the Kyle Carruth, Chad Reed shooting. I covered that right after it happened with a detailed legal analysis, and I've done a few updates, including following the No True Bill this past week in that case. So you got to keep up with the content, folks. If you don't keep up, I can't constantly, put the gears in reverse and go back and cover the same ground over again. Yeah, this girl doesn't want to be there. I don't blame her. Most people don't want to be witnesses. I'm frankly more comfortable with witnesses who'd rather not be there. I get more concerned about witnesses who suddenly they find themselves to be the center of attention. Those kinds of witnesses can be problematic because they can go theatrical on you, which is not what you want. Let's see. Yeah, in terms of, could the jury just nullify a conviction here? Do the jury nullification thing? So jury nullification is both a thing and not a thing. It's not a legal thing. It's not an argument a lawyer can make. It's not recognized under the law. The jury will be instructed to apply the law as instructed by the judge, whether they like that law or not. So they're not allowed to jury nullify. On the other hand, no one knows how a jury makes a decision. So if they decide to, inside their heads, just not convict this guy, no matter what the evidence in the law, nobody can stop them from doing that. But it would need to be unanimous to get an acquittal, just like it has to be unanimous to get a guilty verdict. If only one or two of the jurors do it, it's just a hung jury, a mistrial, and
Yes.
I presume they would try this guy again.
Did you interact with the dog at all?
Not physically, but
Hold on.
Now they're asking about the dog.
And they
We have
have a problem
another
with this.
immediate objection.
That's the recording.
I did not see footage of a police shooting at a wedding in Florida, so that hasn't popped up on my radar screen. Favorite legal movie is My Cousin Vinny. My Cousin
Go ahead,
Vinny,
counsel.
hands down.
Just re-ask your question, please.
Did you interact directly with the dog?
not physically, but I saw the dog a lot.
I'd like to approach.
They should print. I believe the dog was about
I'm
20
showing you-
pounds. They
I'm gonna
should
show you
print
what's
it up on a
marked for
photo board,
identification
a
as
giant
Defense
photo, so it looks like
Exhibit
a llama.
800-90. Is that picture, in your mind, an accurate picture of the dog?
Yes,
What was the dog's name?
Rosie.
Were you scared of the dog?
Yes.
Objection.
What's the relevance of this?
Look at the prosecutor laughing there.
I mean,
He just snuck that in, and the judge is pissed. She's not charged with the use of force crime. She's not trying to justify anything. What does it matter what in her head she thought about the dog? Yeah, folks, if you think you're just going to hop on a jury and tell everyone about jury nullification, you'll be held in contempt and you'll be put in jail. And the judge has a lot of discretion for how long you stay there. If you're going to do jury nullification, I would encourage you to just do it inside your head. Well, the Orlando wedding event looks interesting based on what I'm seeing in the comments. So yeah, I'll dig it up after we're done with these proceedings today. Yeah, for all the people who are on law and crime saying this judge is mean, he's as reasonable as I could imagine. Imagine what Borkowski would be doing with these lawyers right now, these defense lawyers, with all this nonsense.
while you were on the farm, commencing in the period of the end of July, we'll say July 31st, through August 6th, were you aware of whether or not the police were called to the farm on a number of occasions?
Yes.
And did you ever talk to the police when they were at the farm?
Yes, I did.
I bet. I bet the cops are more than happy to
When
chat
you
up this
talked
young
to the
lady.
police, did you observe their reaction to what you were telling them?
Yes.
And what reaction did you observe of the police when you told them the information you gave?
They were very nonchalant and they just turned around and walked away.
Did you ever feel threatened by Robert Goodwin?
Objection, Judge. We just talked about this.
All right, members of the jury, we're going to take our morning break now.
The judge is very unhappy.
You can step off the stand.
Just watch your step.
I wonder if the judge is going to keep his mic open for this chewing out the defense is about to get. What this girl thinks in her head is not by itself relevant to what the defendant might have been thinking in his head. It's not relevant. That she might have been afraid of the dog doesn't mean Michael Barisone was afraid of the dog. That's not evidence of what he's thinking. That she might have been frightened of Robert Goodwin, and God, who knows how a guy like Robert Goodwin would be eyeballing this young woman every time she was on the farm, and apparently she lived on the farm, just like Robert Goodwin did. I can easily imagine that situation going super creepy. But just because she was uncomfortable with Robert Goodwin doesn't mean Michael Barisone was similarly uncomfortable with Michael Goodwin. I mean, it doesn't even make sense. The reasons she might be uncomfortable would be completely different, not applicable to Michael Barisone. So, and of course, the defense counsel knows this. They're just trying to sneak it in so they can talk about it on closing. But they know it's inappropriate, and the judge is going to let them know. I sure hope he keeps the mic open. Let's see what happens. Look at him shake his head. The little judge head shake. Are they going to chambers? Oh, damn it. He's back. That is not a happy judge. Oh, the mic cut out. Should I just ad-lib it? You know you can't do that. You know that's inappropriate. Do you have an explanation for why you're effing around in my courtroom like this? You know this isn't your courtroom, right? You know this is my effing courtroom? Oh, man. But when you got that was a little bad lip reading, right? That's what they call that. That's I don't know. I guess the defense probably feels like they've got nothing else to work with, and if that's their assessment, I'd have to agree. I don't see anything here to support any theoretical defense for this defendant, other than maybe diminished capacity, maybe just hoping the jury will have some sympathy. By the way, and that can work. The jury having sympathy can work. It's not a legal argument. It's an emotional argument. And of course, none of us can see the jury, right? We don't see their facial expressions or how they're responding to things, whether they're napping or they're rolling their eyes, or, we don't know that, but the lawyers know it. The lawyers are watching the jury. They're seeing those reactions. Certainly the defense, which asks its questions standing up and walking around, often standing beside the witness stand and looking towards the jury, they're seeing those reactions. So maybe they're seeing something we don't see because the jury is not exposed to us. I do find it weird how the prosecution rather, just stays seated asking questions. Now, I know he can't just stand up at his table to ask questions because then the camera angle would probably expose the jury. But man, if I were the state, I would have figured out some place to stand in the courtroom that was acceptable to the judge where I'm standing up so the jury's not behind me, so I can still see how they're reacting to what's going on, because that can tell you a lot, folks. That can lead you to double down on a line of questioning super hard or drop a hot potato super quick if you see it's going against you based on their facial expressions and demeanor and physiological appearance and all that kind of stuff. Let's see. Yeah, I mean, we don't even know if she was afraid of the dog, that her fear was a rational fear of the dog. Did the dog ever bite her? I mean, was a dog known to be a biter? There's no evidence of that. And I can assure you, if there was evidence, the defense would have admitted it. So let me take a look while this nonsense is going on. I guess I should, well, I'll take a quick look at the super chats. That's all good. Let me take a quick look at the Law of Self-Defense member page. Let's see. David asks, is it possible the defense attorney wants him to go to prison? I doubt that very much. It wouldn't surprise me if defense counsel Blancas thought he was doing a fine job. I mean, sometimes people are just completely blind to their incompetence. Maybe he's one of these lawyers who goes in every day. Like sometimes you meet athletes like this. They lose every game, but if you ask them, it's always somebody else's fault, right? We all know people like that. Blancas could be a lawyer who loses every case, but it's not his fault. Maybe, I guess. Let's see. All right, I'm going to go ahead and fast forward this and see if we get to anything more. Let me see if... so that was Jordan Osborne. Who's next? A defendant's friend, an attorney, and someone who trained the defendant. Joe Williams trained the defendant. Should we fast forward to the attorney? Yeah, let's fast forward to the attorney, see what that's all about. So the next witness is, I guess we're not done with Osborne, right? With the young lady. So let me fast forward here, see if she comes back. I mean, I just don't think the defense really has any questions to ask. She does come back. Okay, so here we are continuing with Ms. Osborne.
Just watch your step coming in.
You may have a seat, Ms. Osborne. Go ahead, counsel.
I have no further questions of Ms. Osborne at this time.
Oh, that's it. So the judge just shut him down completely. Good Lord. So what would have happened basically is the judge said, listen, I want to know what you plan to ask about and what kind of answers you're looking to get out of this witness. And they told him, and he said, nope, none of that is happening because it's all inadmissible. It's all prejudicial. So that was it for the defense on, this is their witness, right? Their direct examination of their witness. So now the state will have a chance to ask a few questions. We'll see if they want to. I was going to mention something else. Oh, the dog. So it's uncontested that the dog bit Michael Barisone during this confrontation. But of course, the state's narrative is that the dog attacked and bit Michael Barisone after he shot the dog's owners, Lauren Canarak and Robert Goodwin, and there's no evidence to the contrary. So. Okay, back with the young lady. Now on cross-examination by the state.
Any cross-examination?
Briefly, Judge. Ms. Osborne, good morning.
Morning.
Have you ever testified in court before?
No.
All right. Is your mother Lara Osborne?
Yes.
What's the nature of her relationship with Michael Barisone at this point?
They're in a romantic relationship.
Well, hold on. Is there an objection, counsel?
I object to relevance.
No, it's relevant. It goes to potential bias. So Laura Osborne's mother is in a romantic relationship with Michael Barisone. So obviously that could bias her testimony, right? Her mom is, if she bad talks Barisone, that could influence her relationship with her mom, right? So it's a potential point of bias. And bias in a witness is always relevant because a core function of the jury is to evaluate the credibility of the witness.
Judge, this clearly goes towards bias. This was explored on cross-examination with state witnesses.
Overruled.
I'm sorry, there was an objection. Could you just tell the jury again what your last answer was?
They're in a romantic relationship.
Thank you. No further questions, Judge.
All right, thank you.
All right.
You swore under oath to tell the truth when you were brought here this morning?
Oh,
Yes,
judges hate
Would you
this.
violate that oath simply because of a relationship your mother was having?
absolutely not.
Thank you. No further questions.
All right, you may step down, ma'am. Thank you.
So that closing remark by defense counsel, I mean, maybe it would be worth something if she had provided helpful substantive testimony for the defense. And there could be a thought on the part of the jury that she was lying about that, but she didn't provide any helpful testimony. What was her helpful testimony? That she was afraid of the dog? Objection. That she was afraid of Robert Goodwin? Objection. Sustained. So really pointless. All right, the next witness is a friend. This woman here is described as a friend of Michael Barisone. I'm not going to bother with that. Married to Franco. But I will go on to the next witness, who's supposed to be an attorney. So let's see what the attorney sees, some more hot lawyer on lawyer action like we did yesterday, perhaps. Of course, the previous lawyer was the lawyer for Laura Kanarek, who was subject to cross-examination by the defense. All right, here's the lawyer.
All right, call your next witness, please.
The defense calls Stephen Parshas.
Stephen Parshas to the stand, please.
So
Please
this
remain
is
standing for a minute, sir. You need
yeah.
to be sworn. Place your
Stephen
left hand on that Bible.
Parshas,
Please raise your right hand. My court
attorney.
clerk will administer the oath.
Do you swear in the presence of Almighty God that the testimony you give to this court regarding this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Please state your name and spell your last name for the record.
Stephen Tarshis. The last name is spelled T as in Thomas, Arshis.
Thank you.
Let's see what this guy's all about.
Mr. Parshas. Good morning.
Good morning.
What do you do for a living?
I'm an attorney.
And how long have you been engaged in the practice of law?
35 years.
Can you give us your educational background?
Certainly I went to City University in New York, attended law school at Syracuse
Yeah,
College of
at least
Law.
this lawyer witness showed up in
Graduate
a
school at,
tie, an actual suit.
What was the graduate degree at NYU?
Wasn't a degree. I went for courses in tax.
Okay. And when did you first become licensed to practice law? If you recall.
1976, actually. I'm licensed both in New York and New Jersey. I was 76 in New York and I believe 80 in New Jersey.
And with respect to your practice in New Jersey,
You don't have to swear to
any sort of
God
focus
to tell the
with
truth
respect
to be a
your
witness.
work?
If you don't want to take that oath, you can do what's called an
When I'm asked that
affirmation.
question, I
That's
usually describe
non-religious in
myself as
nature.
a business transactional lawyer. But over the last 5 or 10 years, I've developed a somewhat unique specialty in equine law.
A horse lawyer.
What is equine law, if you could briefly describe that for the jury?
Horse lawyer.
Basically, it's providing the horse community and people involved in horse businesses, whether they be amateur owners, professional riders, breeders, trainers, both on the sports side as well as the racing side.
Remember the criminal charges and defenses here, folks. The criminal charges are attempted murder, 2 counts, and the theoretical defenses are self-defense, insanity defense, imperfect self-defense, diminished capacity, and a wish that the jury will just be sympathetic. What's this horse lawyer going to contribute to any of those legal defenses? He wasn't present, so he can't have any helpful testimony for self-defense. He's not a psychiatrist or psychologist, so he can't contribute to insanity defense. He's not going to contribute to imperfect self-defense for the same reasons, well, for both those reasons. Diminished capacity, is he going to argue that in his opinion, the horses were being badly treated because he's a horse lawyer? He has expertise to know that. I just don't see the relevance here at all.
Have very many of the same business issues as most businesses, buying and selling horses, importing, breeding situations, syndications of race horses and sport horses. Unfortunately, at times, sometimes litigation. So because of the unique nature of the people and the rules that are associated with the sport, a specialty of, I suppose, very few attorneys who do it has arisen, and I'm one of them.
Has your specialty and your past experience ever touched upon the issue of boarding arrangements for horses and training arrangements for people?
Oh, quite frequently.
Could you briefly describe your experience in those areas?
Well, many of the clients I've had are on both
This poor
sides.
defense counsel,
I have
you
clients
can't
who
see the
are
bald spot from his
operators of,
front. The camera
equestrian
shows it to you
boarding
from the back.
facilities, commercial
And that
facilities.
camera, that giant
So
TV
they will
behind
have
him.
come to me, they will come to me, I should say, to prepare boarding agreements for the people who board their horses with them, setting out the rules, the terms and conditions under which the owner and operator of the equine boarding facility will care for and take care of a person's horses. And on the other side of that, it's the person who has a horse and they want to place their horse in the care of an equine facility. So they will ask me to review frequently a boarding agreement to make sure it's fair and equitable and that their horse is going to be well cared for and their rights are going to be protected. So it's like any contract transaction, it'll be both sides of the transaction in a boarding situation.
A specialized form of contract?
Yes, very specialized.
Do you know Michael Barisone?
Yes, I do.
How long have you known Mr. Barisone?
Somewhere between 10 and 15 years, I think, at this point.
And
Have you ever met
how did you
Mr. Ed?
first come to
You
know
ever
Mr.
provided legal
Barisone?
services for Mr. Ed?
I first came to know him as a trainer.
For Secretariat?
I was training with a young woman who was to whom Michael was a mentor. She was a professional, and she would frequently, for her own benefit, take lessons with Michael.
You ever met a
And
horse
she
that could fire a
introduced me
pistol?
to him, and over a period of time, seeing his skill and ability and what he was able to do, and aware of his reputation, I began to take lessons with him as well.
Well, so let's
Oh,
take
another
tangential
dressage
turn
student.
in topic for a second. Are you also a horseman?
Yes, I am.
Okay, and how long have you been pursuing horse-related activities?
Over 30 years.
Do you consider yourself to be a hobbyist, a professional, something else? What do you consider yourself to be?
My time would say I'm a professional. The fact of the matter is I'm an amateur. It's something people who are
He's another horse
involved
nut.
in the sport in a serious way understand it's a different kind of sport. It's not a hobby. It's not like golf where
It's
you
a
play
calling.
and you put your clubs in the closet. Becomes a matter of
Tell you one thing, you can't fit a horse in a closet.
Is it a passion for you?
Oh, most definitely. I ride at least 5 times a week. I devote at least 15 hours a week to it. I compete up and down the East Coast.
That goes all his credibility.
Might sound like a naive question.
Ever dress up your
but
horses in
that's what
outfits?
We're here for, to get a full explanation. You ride. Do you also own horses?
Yes, I do.
Over the years, how many horses have you owned?
Oh, God. Well, I have both sport horses and race horses. The interest in racehorsing is a little different. It's common
Sir,
for
are
there
you
to
aware
be
of how
what's
glue
known
is
as
made?
fractional ownership in racehorses, unless you're very big, very frankly, very wealthy or run the business. Most racehorses are owned by 3 or 4 or 5 people. Sport horses are usually owned individually. Over the years, I've probably had 15 or so.
Sir, we'd like you to come into court and testify
Horses
about
that
your
I've
hobby.
ridden and competed with, and probably 10 or so racehorses in which I've had an interest.
Would you be interested in
And
doing
is there
that?
a
Oh, yeah.
particular area of horse sports that you focus?
At the present time, I've competed in the 3 major disciplines: eventing, show jumping, and dressage. For the last 10 or 12 years, it's been dressage.
And was it dressage that brought you to Michael?
Yes, it was.
Okay. And what was it about Michael's reputation that made you want to train with him?
Like any teacher, the ability to communicate to a student is what makes, in my view, an exceptional or good teacher. And Michael had a very gifted way of communicating.
What does
very
any of
difficult
this have to
sport
do with anything
and making it understandable so
of
that
relevance to this
amateurs,
trial?
such as myself, would be able to learn.
So he's a good horse instructor.
Yeah,
That doesn't privilege him to shoot people.
For communication and a tremendous empathy for the horses, of course.
Did Michael train your horses too?
No, he did not.
Okay. But he trained you.
Correct.
In your experience with training with Michael, did you ever witness him riding a horse?
Oh, absolutely, sure, many times.
In all the times that you witnessed,
Did he shoot you?
Michael using a horse, riding a horse, did you ever see him do anything harmful to the horse?
No, absolutely not. Michael considers his horses gifts from God. He would, I think that might have been a quote even. He treated them as most horse people do, very special and creatures to be cherished. And he was, if anything, very, very indulgent, but never abusive.
So he was your trainer.
Yeah.
And was he, did you still have a training, pardon me?
A
Did
trainer.
you still have a training relationship with him in the summer of 2019?
Not really. I say that not really because it was intermittent. Normally when you have a trainer, as I do now, it's a consistent relationship where you train with the same person, on a daily basis. With Michael, it was an occasional clinic or an occasional lesson. So I can't say it was really, if I had called up Michael and said I wanted a lesson, I would have had a lesson.
Did Michael's
I
dog
didn't do it,
scare
so
the
there was
crap
no-
out of you?
Not a real training relationship at that point.
20-pound
Over the
Rosie.
years that you worked with Michael and knew him, did you develop a friendship with him?
Yes, definitely.
Well, tell me about your friendship with Michael over those years.
It was very soon there after I started taking lessons and training with him. Michael and I, for whatever reasons, had a real empathy with each other. We kind of connected, both mostly through the love of the horses. We're also, to be very candid, somewhat unique in the sport, in the sense that dressage particularly is a sport dominated by women. I know for a fact that 90% of the members of the United States Dressage Federation are women. So men don't usually participate in the sport. So, that was kind of, we draw each other to, because we were kind of, oddballs in the sport. And even though he was a tremendous, successful, international reputation professional, and I was a lousy amateur, that kind of brought us together, and we just liked each other and got along and enjoyed each other's company.
Did you socialize with him?
Oh, yeah.
Did you socialize with him at the farm in Long Valley?
Yes.
Did there ever come a time when he became your client for purposes of legal services?
Yes, there did.
Okay, and when did he first become your client for legal services, if you recall? I'm not asking you to tell us anything about the specifics of the
It's
representation.
over 10 years ago, but I couldn't, I'd have to go look at my files and see.
I know.
when
Thank God they're talking about
first-
legal work. I thought the
Probably, but
next
it's-
question was going to be, and have
I'm
you
sure
ever
10
seen
years
Michael
ago.
naked?
So over that decade,
Did he
how
have
would you
dog
describe
bites at
your
that time?
professional relationship as his attorney? Was it intermittent, constant, something else?
Well, the work would be intermittent because it's not the nature of something that comes up every day. But in my mind, I believed he considered me his attorney. Whenever a legal matter was, anytime the services of an attorney were needed, he always called me. But it could be 3 or 4 months could pass, or 2 weeks could pass, or 6 months could pass. There was no consistency to it. It was when the need arose. But I'd like to think, I certainly did, think that he thought of me as his attorney.
Well, let's move specifically to the time period of July 2019, or actually, let's start it in June through the day of the incident. You're aware that an incident occurred on August 7th, 2019?
Yes, I am.
All right, so from June of that year to the date of the incident, did Michael contact you requesting your services?
Yes, he did.
And was it a matter you had previously consulted with him on, or something new?
Something new.
Without revealing any client confidences, what was the subject matter of that engagement?
He called me to tell me that he had a client.
Gentlemen who object. that it's
Yeah,
hearsay.
let's
I
not get,
understand
let's
where we're
not,
going.
right, let's not get into the specifics of what was said.
I understand.
So the
Right.
question would be to describe what the matter was, but without using
Yes.
someone's words.
I understand.
Okay.
Of course I do. The purpose for which he called me was
Maybe he doesn't have a lot of hearsay issues in
that
horse
he,
law.
um,
no one's
he had a problem
reciting
with
a
a
horse's
particular,
out of court statement in
boarder
court for the
who he
truth.
wanted to leave the farm, and the person would not leave. That's as simply as I could put it. It was much more complicated than that, but that's about as simply as I could state it.
Did Michael identify to you that border?
By name, you mean?
All this
Yes.
stuff would be
And who
privileged,
was
arguably,
Canada.
if it was being asked by the state without the consent of the defense. But this is the defense calling this witness, so presumably it's
Following the
consented to.
time when Michael called you to engage you on this new matter, did you come to the farm?
Yes,
Do you recall coming to the farm in late July of 2019?
I was at the farm several times, and certainly in late July.
Do you recall having conversations with Michael about the matter that you were representing him on with respect to Lauren Canarak?
Yes, I did.
Did any of
Look, you
those
get his bald spot from
conversations,
both directions.
uh,
Oh, poor guy.
occur in public areas such as, well, let's specifically, did any of
Given
those
this is a courtroom, they're
conversations take
probably
place
afraid to
in
turn
the
a TV
locker
off
area
because it
of
might
the
not
farm?
turn back on again.
I don't recall any taking place there. There were so many conversations. I know where the vast majority of the conversations I can say with certain took place, but I don't have a specific recollection of anything in the locker area.
Are you personally familiar with the locker area?
Yes, I am.
Let me show you a photograph that was moved in evidence as 800-42. Let me know when you've had a chance to review.
I know it very well.
Does that photograph accurately depict how the locker area looked when you were on the farm in the late July, early August time period of 2019?
Yes, it does.
Is there a bench in that area?
No, and there was no bench there.
Now, you said you could
was a
recall
bed.
where certain conversations took place. Did you say the vast majority?
Correct.
And what's your recollection as to where the vast majority of your conversations with Michael took place?
It was an area that was referred to as the lounge area.
And you might need this picture here. Where was the lounge area located?
It was the center of the farm, of the building that comprised the stables and the barn.
Was the lounge area the club room?
It was a club room. I can tell you that this staircase here, if you walked up this staircase, there was a door here. And if you walked through that door, you entered into the lounge area. The lounge area was when you came to the front, the entrance to the farm. There were double doors. And if you opened the double doors, there was a very, very, very large room. That was the lounge area. In that area was a kitchen area.
Oh, come
In that
on.
area was a huge pool table. And in the center of the
Please,
area,
state, put us out of our misery here.
couches and seats. The reason it was there was because there was a glass wall, and which was not unusual for a lot of horse facilities. The idea was that clients and friends could sit in the lounge area, look through the glass, and watch, their kids, their husbands,
Horse
their
gazers.
mothers, their daughters.
I'm going to
watch them
grab
ride.
some more coffee, folks.
So
I'll be back
that
in a
was
second.
That was pretty obviously the purpose of the lounge area. And that's where, because it was the largest area at the farm and very comfortable, obviously with couches and chairs and a kitchen where people would congregate. And that's where the vast majority of my conversation with Michael took place.
Was Lauren Canarak ever present in the room when you had conversations of that nature with Michael Barisone?
No, absolutely not.
Did there come a time in late July or August preceding the incident that you became concerned that your private conversations with Michael Barisone were somehow being overheard by Lauren Canarak?
Yes. Excuse me. Yes.
What happened that gave you that concern?
Well, unfortunately, this had dragged on, the whole incident, and getting worse and worse almost by the day. And given the very, very almost, I hate to put incestuous nature of the horse world, what was going on at the farm became common knowledge within the horse community. So there was a tremendous amount of social media being posted about this stuff. And I believe, I heard it from so many different sources, but I believe I first became aware that she was claiming to have heard conversations. I believe I first became aware of it through postings on social media.
Was Robert Goodwin ever in the room when you were having private conversations with Michael about the matter?
No, I've never met Robert Goodwin, never seen him.
Did you ever see any social media postings with respect to what was going on at the farm
Oh, God, yes.
prior to the incident?
Yes.
Oh, God, yes.
How did you obtain access to those postings?
Well, I'm not a social media person, but they would be pointed out to me by Michael and Mary Haskins Gray. Justin Harden might have done it. You know, a lot of this, I don't remember specifically the source after, you know, it was such a chaotic time and so much was going on. So I can't necessarily pin down where I might have heard something. I just know I heard it, and these are the likely places that from whom I would have heard it.
With respect,
And then I would go look and see for myself. Yeah.
so with respect to the postings that you saw, did you see any that reflected words that you had spoken in private to Michael?
Yes.
How many such postings did you see?
One particularly stands out because I was so stunned. It was really disturbing because it was like, you know, it was like somebody was in the room, like she was in the room. And it was very, the only way she could have known it is somehow by hearing it, because it was such a narrow, specific conversation. It wouldn't have been something that would have been passed along to other people in idle gossip and conversation.
So you used the pronoun she in that description. To whom were you referring?
Lauren Canarac, I'm sorry.
Lauren Canarac?
Yes.
Did there come a have Lauren, Robert Goodwin, and her horses leave
That just
Michael
jumped, right,
Barisone's
folks?
farm?
In idle gossip and conversation.
So you used the pronoun she in that description. To whom were you referring?
Lauren Canarac, I'm sorry.
Lauren Canarac?
Yes.
Did there come a
Yep.
have Lauren,
Sorry, folks. That was long
Robert
crime.
Goodwin, and her
I
horses
don't do that.
leave Michael Barisone's farm?
Yes.
And did you make any arrangements for Lauren Canarac and her horses to go to another barn?
Yes, I did.
What arrangements did you make?
Understand, I never spoke to Lauren Canarac, and I had never met CONVICT until actually something that occurred recently. But I never saw her, didn't know her. I only spoke with her father, Jonathan Canarac. And he and I had,
Well, without getting into the spoken words,
Right.
I'm asking you what arrangements
well,
you
I'll
made.
tell you, yeah. He and I spoke about negotiating an arrangement whereby she would voluntarily leave the farm so that other judicial means to have her removed would not be necessary. And that's what we talked about, a negotiation of those terms so that she would leave.
Did you identify a specific farm where she could go?
Yes, I did.
Was there a specific
called
trainer
hell.
involved with that farm?
Yes, there was.
Was that trainer in some manner equal to the level of training that Michael could offer?
Yeah.
Objection.
What's the basis for the objection?
I don't think there's there's a foundation for that question, Judge. It also calls for his opinion, and I'm not sure what the relevance of that opinion would be here.
What's
Another question?
Yeah,
Your
I'm
Honor,
not
he's
sure
not
what
a
the relevance
biologist.
Of his opinion is. But certainly the arrangements that he made is something you can get into.
So that trainer, Was it an Olympic level trainer?
Had won a gold medal at the Pan American Games, equal to an Olympic rider, yes.
And did that trainer have a facility with similar to Michael's?
Absolute equal to, and it was approximately 15 to 20 minutes from the Long Valley location where Michael's farm was.
Imagine how that other horse trainer would feel if Michael Barisone had ditched this apparent witch, Lauren Canarak, this monster, onto that other trainer. I mean, Michael Barisone's not going to say, "Hey, listen, I've got this woman who's absolutely nuts, is trying to destroy me emotionally, psychologically, legally, professionally, reputationally. Any chance you'd want to take her on as a student?" Is that how that conversation went?
And did that trainer have stalls available for Lauren Canarak's horses?
Yes.
And did you communicate that information to Jonathan Canarak?
Yes, I did. And I communicated the individual's name, who was known to both Lauren and her father.
Following the time when you communicated that to Jonathan Canarak, did you have an understanding as to whether or not there was an agreement that Lauren and her horses were going to leave Michael's farm?
Objection.
Let me see that sidebar, please.
So I don't really know where all this is going, except again to cast the victims, Lauren Canarak and Robert Goodwin, here into an appearance of being the monsters that they appear to be. I mean, they appear to be absolutely horrible people. But that's not going to help you in a self-defense argument, because that's not justification for the use of deadly force in self-defense. It doesn't contribute to an insanity defense. So both perfect legal defenses are not helped by this. Imperfect self-defense is not helped for the same reason. Diminished capacity, or just the wish that the jury finds these victims so vile that they'll acquit or at least mitigate to a lesser included offense because of how monstrous Lauren Canarak and Robert Goodwin treated Michael Barisone. Maybe. I don't know. It's not where I would put my money. But then again, fortunately, my money is not at stake. So that's always good. Let me see if I need to. Sometimes these sidebars go on and on. Oh, now he's happy. He's talking about his horses again. Let's see. Could you tell us about the name of your favorite horse? Here we go.
The objection sustained. Rephrase your question, counsel.
It's a narrow question.
This will be the last one.
Well,
Well,
it's going to be a new one.
he's
A common pattern here, by the way, folks, is that the defense on direct goes increasingly off the rails until the state can't take it anymore. The state objects. They have a sidebar. The defense comes back and they ask one final question because that's all the judge is allowing them.
he's
I understand.
yeah. He's gonna rephrase the question. Go ahead, counsel.
In your negotiations with Jonathan Canarak, what was your perception of his role in those negotiations?
So Jonathan Canarak is the father of Lauren Canarak. And apparently Jonathan Canarak's a retired attorney who did much of the negotiation on behalf of his daughter, Lauren Canarak. Even though Lauren Canarak's in her 40s, she's not speaking for herself. She's having her daddy speak for her, which I'm told is not that unusual a thing to find in the horse community. I don't really know the horse community, but apparently these gals with a keen interest in spending their lives riding horses, and gals who have daddy issues is apparently a Venn diagram that looks a lot like a circle. I'm told. I have no personal knowledge.
Being a lawyer and having to answer these questions sometimes is a challenge because I'm kind of monitoring myself.
Right, so limited to your perception.
I understand. I
Okay.
understand. His role was to speak on her behalf, to find a place that she found acceptable based upon her own standards, her own requirements, where she therefore would voluntarily leave Michael's farm and go to another location. And his role was to negotiate the terms that would be acceptable to her.
Did she leave the farm?
No, she did not.
Did there come a time after those negotiations occurred that you wrote a letter
And this guy looks like Dom DeLuise a little bit. In the movie of this trial, Dom DeLuise would play
providing
this
some
part.
sort of notice to Lauren Canarac?
Chevy Chase could play this attorney
I'm
witness for
confused because
sure.
You're leaving out a piece. We negotiated. an
Loved you in
understanding.
American Vacation, man.
I believed, I believe we had an agreement.
Objection, Judge.
Well, it's his understanding.
That was the basis for the last objection that we addressed at sidebar.
I know, but that's I'll allow that. It's his understanding based on his interaction. So it's sufficient without anything more. It was his understanding there was an agreement. What's your next question?
I'd like to show you what's been marked for identification as Defense Exhibit 700-3.
Yeah, whatever happened to Dom DeLuise? He hasn't been in a movie since the
Why don't you
70s,
take a
right?
moment and look at that?
In the 70s, he was in a whole bunch of them. Often with Burt Reynolds. Bo Bridges. Oh, yeah. A lot of age revealing going on in the chat today. Well, I assumed Dom DeLuise was dead. I just didn't know what happened to his career. He seemed to disappear long before he died. Oh my God, this defense witness is going to play lawyer on the witness stand. He's going to closely read this agreement as if he's about to hand it to a client for signature. Just supposed to be refreshing your recollection, dude. You don't have to memorize it. Yeah, today's movies are terrible, folks. This cancel culture we live in, there are very few good movies being made today, for sure.
Okay, yeah.
Look at this guy. Well, I think there's a punctuation error on page 86. Yeah, imagine having to grow up like today's kids in a culture without a sense of humor. I mean, it's always been the case that about 30% of the population doesn't have a sense of humor. They don't know they don't have a sense of humor, but they don't, in fact, have a sense of humor. They just laugh when they hear other people laughing.
700-3.
They respond to cues.
Yes, I have.
But today, no one can have a sense of humor.
Do you recognize what that is?
Yes, I do.
All right. Is that a letter you drafted?
Yes, it is.
All right. And was there a date on the letter that you drafted?
August
sir?
5th.
And have you memorized it
Go
now?
ahead, ask your next question.
This particular copy I've shown you is unsigned. Do you agree?
Yes, it is.
Did you cause a signed copy of this letter to be delivered to Lauren Canarac and John Goodwin?
Absolutely.
Robert Goodwin?
Robert Goodwin.
Robert Goodwin. No, to Jonathan Canarac and to Lauren Canarac. Not
There
to-
we go. I
not-
misspoke.
Not to Robert Goodwin.
Okay. And did you give Lauren Canarac notice that she needed to vacate the farm?
That's what was the purpose of the letter, yes.
I moved 700-3 in evidence.
Well,
I would object, Judge.
yeah.
In testimony about it, it's hearsay.
And again, what's the relevance? I mean, if this were a civil case over tenancy rights and eviction proceedings, then the notification would clearly be relevant to the legal arguments in that kind of case. Lauren Canarac was sent a letter that they wanted her off the property. I mean, like it or not, she has tenants' rights. She's privileged to argue against whatever the grounds for throwing her off the property are. Maybe she's wrong. Maybe ultimately she gets thrown off, but she's allowed to argue that out in court. But this is not a landlord-tenant case. This is an attempted murder case. So what's the relevance of the fact that she and her father may have been delivered a letter telling them to get off the property? She's not a trespasser until a court says she can't be there anymore. If she were a trespasser, that could be relevant to a use of force case for sure, because someone who's unlawfully present or unlawfully enforceably present can trigger all kinds of special provisions of use of force law. But she's not a trespasser simply because her landlord's told her to leave. He doesn't have an absolute privilege to make her leave. More sidebars, more sidebars. Oh, this one's going on for quite some time. Yeah, okay, here we go.
The objection sustained, but questions, counsel, you can ask questions about.
So again, state objected, long sidebar, objection sustained in favor of the state. Every single time, it seems, that I've seen so far.
The content of the letter.
Can you tell me specifically, from your own recollection, the date or dates when you were having these negotiations with Jonathan Canarak?
It would have been the Friday preceding this, which I guess would have been the 2nd, I suppose. Yeah. And the week, at least the week before that, and maybe even the week prior to that. It went on for some time.
So when you say the 2nd, you're referring to August 2nd,
Correct.
2019?
Yes.
And you're saying that it was occurring on that date as well as potentially the week before?
Yeah, I mean, the specific dates, of course, are days I can't remember. But I know we had several conversations, and it took quite a bit of back and forth to get to the point where I thought we were on the Friday preceding this letter.
And do you recall giving Lauren Canarak a specific date and time by which you were demanding on behalf of Michael Barisone that she vacate the premises?
Yes, I do.
And what's your recollection?
August 7th, Wednesday, August 7th.
And did you cause this letter to be delivered to Lauren Canarak? I think I asked that, but if you could just say again.
Yes, I did.
And on what date did you cause it to be delivered to her?
I can't recall. I can only assume it was the date that it was delivered by email. So it would have been delivered the date it's dated, August 5th.
August 5th is the date?
Correct.
Okay. Was Michael aware that you were sending this letter?
Oh, yeah.
Did Michael express to you any concerns about sending this letter?
Yes, he did.
What concerns did he express to you?
He didn't think she would leave. He didn't.
Subsequent to the delivery of that letter, did you proceed with any actions toward legal proceedings against Lauren Canarak and Rob Goodwin to have them vacate the farm?
Yes, he did. And I have to confess at this point, my memory is a little fuzzy. I did what I said I was going to do, and I initiated an eviction proceeding, which, and she was served with a complaint and eviction.
Let me show you what I've marked for identification as.
So to be clear, a complaint of eviction is not an order of eviction. A complaint is what the landlord files to initiate the process that the landlord hopes will end up with a court order of eviction. Once the court's issued an order of eviction, then a sheriff may show up and actually physically remove the person from the property if they're not already gone. But until that order is issued, that tenant has rights to contest the complaint.
Document 700-5. Could you review that for yourself?
Now,
Oh, there's no question pending. I'm just
Okay.
asking you to review it. Okay?
yes,
So, you've reviewed Exhibit 705, correct?
yes.
Let me show you what I've marked for identification as Exhibit 704. Please review.
So to address this super chat real quick about getting an order of protection, I Shut Up, I Can Cook posted a couple, well, 2 super chats. Thank you for the one saying you're just enjoying your day off, but the more substantive one asked about Branca. Why could he, Michael Barisone, not get an order of protection? I did, and the cops gave my relative 10 minutes to grab his stuff and escorted him out. I presume Shut Up, I Can Cook is of the female gender. I do have some biology training. Also, I went to the prom. But there's a huge difference, just politically speaking, between a woman asking a judge for an order of protection against a man living in her home. If she makes any suggestion of a potential of violence, the judge is going to issue that order because the judge is scared to death. If he doesn't, the man will end up killing or injuring the woman, and the judge will be held accountable in the media. It'll be a firestorm. That's hugely different than a male trying to get an order of protection against a female living in a different building on a large piece of property where he can't enunciate, he can't articulate her being an actual threat to him, against which he would need an order of protection. She's just being mean. She's not threatening him with physical harm. So no, the prospects of him getting an order of protection that would somehow get around her privileges as a tenant when she's living in a different structure, not in the same home as him, it's a completely different set of circumstances. But a good question. So thanks for asking. Okay, back to this horse lawyer.
Do that and let me know when you're ready.
I know when I'm ready. I'm ready.
You're ready now?
Yes.
Okay. What is Exhibit 704?
This is an affidavit of service of the eviction complaint on Lauren Canarak.
What is Exhibit 705?
The verified complaint, which was served pursuant as reflected by this affidavit of service.
Do you have a refreshed recollection as to the precise date when the eviction complaint was served on Lauren Canarak? Yes or no?
Yes,
What's your refreshed recollection?
August 6th.
Okay. Thank you. I'll take these. In connection with spending time with Michael in the time period from July 31st through August 6th, did you notice any changes in his affect?
Well, the change that I noticed preceded those days, but certainly very much so in those days, yes.
Let's move it back further then. Let's take it from July 15th forward. Were you in Michael's presence in July of 2019?
Yes, I was.
Did you notice changes in his affect as it got closer?
Thanks, C. Goody, for taking out the garbage. I appreciate it.
Excuse me. Absolutely.
What were your observations?
He became very, very upset, almost to the point of being unable to function. As an attorney, and this was my client, it got so bad I couldn't even have a conversation with him. He was in constant fear of so many things, and all he would talk about, he was in a loop. All he would do was talk about the fears that he had. And here I am trying to be a lawyer to a situation and proposing solutions or possible paths to take, and he wouldn't deal with them. It was difficult to have a conversation with him. He was constantly agitated.
So all of this could be relevant to a diminished capacity defense, reasonably enough. I'm not sure why it took so long to get to this point, but
at times he was incoherent. It got so bad that I threatened to quit. I said, I'm not serving any purpose. You're not listening to me. You're not hearing me. I remember screaming at him. I screaming at him, not him yelling at me, because I was so upset that he was just ignoring me. I don't think I realized at the time, how out of it he was. And it only perhaps was later, as we got really close to the 6th and 7th, when he became just, non-functioning, just completely, he couldn't function.
Did the fears relate to Lauren Cataract?
Totally to Lauren Cataract. He was afraid that, aside from her,
I'm going to object.
Yeah. Sustained.
And by the way, folks, I have to assume the defense is overreaching like this because they do not intend to put their client on the witness stand. Probably for good reason.
Based upon your professional relationship with Michael, did you have an understanding as to his finances?
oh yes,
And did you have an understanding as to Michael's net worth?
I had a pretty good idea. I don't think I would say I had a really exact or precise understanding, but I knew he was very, very unique in the horse world.
How is he unique in the horse world?
Again, bearing in mind, and it's hard if you're not part of this community, this is an incestuous community where everybody knows
Oh,
everything.
incestuous, I bet.
Michael was unique that he was a successful businessman. I mean, they're, with all due respect to their professional
Most
accomplishments,
horse
they're
people
Olympic riders
are
who don't have a
financial
nickel to their
idiots.
name. They rely on sponsors to support them.
It's worse
Michael
than a
had
boat.
accumulated wealth in the millions.
Boats don't poop on the
and
floor.
It's just not done. He was a brilliant businessman.
I have no further questions at this time.
All right. Cross-examination?
Mr. Tarshish, do you have any awareness of what Michael Barisone's monthly expenses were?
No.
Do you know anything about how much it cost him to run the 2 farms that he owned?
No.
Or pay payroll?
No.
Take care of the horses?
No.
Now, you were asked a question by Mr. Dininger about being contacted by Mr. Barisone.
So all of that completely undercut this claim that Michael Barisone was exceptional in the horse community because he was a good business person. This lawyer just said, well, I don't know any of the facts that would be necessary for me to have an informed opinion about whether Michael Barisone was a good business person.
With respect to the issue with Ms. Cataract.
Correct.
Do you remember when you were first contacted about that?
Precisely, no, I don't. The best I could tell you, it was either late June or the early part of July. Because my reaction was, when he spoke to me, he had told me of a situation that had been ongoing for months. My reaction was, why didn't you call me sooner? So I think it was late June or early July.
So you think he contacted you somewhere a month to 6 weeks potentially before the shooting?
Could be, yeah.
Do you have records of that?
No.
You were his lawyer?
Yes.
And this was ongoing. You had been representing him for approximately 10 years or so at that point?
On and off, yes.
And he contacted you about an issue that he had with this quarter and wanted to take action?
Yes.
You weren't aware of any specific written contracts that Mr. Barisone had with Ms. Cataract related to their business arrangements?
I was aware there was no written contract.
Now, if I could just ask you, Judge, may I approach?
Yes.
Absolutely. Yeah.
Mr. Tarshish, I'm just showing you again what's been marked as 705 and 704. And I'm just trying to get the timeline right.
Sure.
704 is an affidavit of service.
Correct.
And does that indicate that it was served on August 6, 2019 at 11:53 a.m.?
Yes, it does.
Who fills this out?
The person whose signature appears, the person who actually served the document upon Ms. Canarak.
And is that based on something that you would have given to that person or that company to serve?
There's the
I would have
defendant.
given them the complaint to serve. They would have served it, and then as a consequence of them serving it, they generate by themselves this document. It's not a form that I give them and they fill in. They use their form and provide it to me.
Okay, so if it says here that the papers that were served on that day and time was a letter, I guess you're saying that would be wrong.
I don't recall. This complaint was never filed.
Oh, it was never filed.
That's right.
Okay. So you sent a copy of the verified complaint unfiled to Ms. Canarak.
He'll stop me, I'm sure. Michael did not want to start eviction. He wanted to scare her into leaving. So we suggested serving her with the papers, but not filing them, hoping this alone would give her the impetus to honor the agreement.
What an amateur hour.
I understand. So that was going to be my follow-up
It sucks to
question,
have
was
a
that
crazy
Mr.
client.
Deininger showed you 705.
Yeah, there's nothing even filled out on this thing.
That's what I wanted to ask you. Right. So, okay. So this is a complaint that's not filed.
Correct.
I understand. And the purpose of sending it was for Michael Barisone to scare Lauren Canarak into thinking that he was serious or something to that effect.
Exactly.
No further questions, Judge.
All right.
Yeah,
You
that
may
was
step
not
down, sir. Thank
that was
you.
not
May
helpful to
redirect?
the
I'm sorry.
defense.
All right, you may step down, Mr. Tarshis. Thank you. All right. Do you have another witness, counsel?
Can I check that?
Sure.
All right, so I see Law and Crime is listing the witnesses on their website as they pop up, and they have the next witness is Joe Williams, who was trained by the defendant, then the lunch break, then Philip Dutton, a former Olympian. I don't think either one of those are going to be very interesting, but I definitely don't want to sit through the lunch break. So I'm going to fast forward and see if we catch up to the end here, see if anything interesting is going on. And because eventually this the defense has to run out. Ooh. That seems an unfortunate look. So this looks like I paused right in the middle of another sidebar. Let's see if I can. There we go. Yep, another sidebar.
Visibility of Lauren Canarak.
Well, it was all black. The only time that you could see her is either when she was standing right in front of me or when she was sneaking by a window that had light shining through, and you see a little shadow figure go shooting by the light.
When you talk about windows with light shining through, what building were those windows in?
The garage.
Was she wearing shoes?
No.
So direct exam of Philip Dutton. I guess this is former Olympian.
Did you have a chance to observe Michael in the days? Well, let me ask this first.
Sorry,
Were
looks
you
like this
on the
must be
farm
Jamie
when
Dancer.
the incident occurred on August 7th, 2019.
Yes.
Okay. In the days
This
preceding
dressage
that,
athlete.
did
I
you
guess it
interact
is.
at all with Michael?
I'll give him that, I guess.
Every
Athlete.
single day.
Okay. And did you notice any
I have a
changes
feeling when
in
you open up the
Michael
dictionary
in
to
those
athlete,
days
you don't see
preceding the
this guy's
incident?
photo.
Yeah, I mean, like, usually he's pretty fun to be around, telling jokes. Like, you know, he's always involved with riding the horses or coaching us. and stuff for market. He wasn't coaching us as much anymore. He wasn't riding the horses that he was supposed to. He was, just seemed like depressed and out of it and stuff.
Did there come a time when Michael did anything unusual toward you that you felt was out of character?
He broke down to me a couple times. At one point, he gave me a hug, which I thought was weird because we never actually really hugged each other.
So was that the first and only time he's hugged you?
Yeah.
Did he have a bottle of wine and roses? Oh, okay.
Were you
All right,
ever,
sorry.
to your knowledge,
Not Jamie Dancer.
mentioned in social media.
Look at the
posted by
defendant
Warren
there.
Counteracts.
His head is in his hands again.
Did you see postings that you interpreted to be about
Objection.
you?
Counsel.
Oh yeah, Jamie Dancer was much earlier in the day. So perhaps this is Philip Dutton, former Olympian. I don't know. I'm not sure it's worth rewinding to find out. But in any case, we're all caught up. This is real time now. Let's see. Well, hopefully things will pick up. I don't have an infinite amount of time today to spend on this particular case. I was hoping to get to a point where we would know for certain whether or not this defendant was going to testify on his own behalf. I hope to God the defense doesn't have an endless stream of these apparently largely pointless witnesses. Oh my God, the worst part of being caught up is I can't just go skip past these ridiculous sidebars, which always have the same outcome. The state objection is sustained and the defense comes back and asks the one final question the judge is permitting them, and that's it. Why would I want to go back and listen to them talk about Lauren sneaking in the bushes in all black? Maybe let's say she was sneaking in the bushes in all black on some prior occasion. How does that justify shooting her twice in the chest when those shots were fired? Guys, just these trials are not soap operas. Just because you find a piece of evidence titillating, that doesn't mean it's relevant. So while this is going on, a super chat just came in. Megan K, do you think there might be an argument for battered person syndrome? I know it's a business relationship, but given they live on the same property, the outcome would be the same as a kind of diminished capacity, which is really what battered person syndrome is, a diminished capacity. So the media normally talks about battered person syndrome in circumstances where normally a female victim of long-term abuse kills her abuser in circumstances that fall well outside of I'm going to pause that live feed just to answer this question. The female abuse victim kills her abuser under circumstances that fall well outside traditional self-defense. So she kills her abuser not while he's in the process of abusing her, but he's passed out, drunk, or he's asleep or whatever in bed, and she pours gasoline all over him and sets him on fire. Clearly, in that moment when he was passed out, he was not an imminent threat of harm to her. So that can't fall under the umbrella of self-defense justification. But what the courts really in every state have done now is they've said, listen, we're going to take into account the fact that she was an abuse victim. And the outcome is effectively to mitigate what would have been a murder conviction to a manslaughter conviction. That's basically what diminished capacity would do. That's what imperfect self-defense would do. A subject of an unreasonable belief in the need to use deadly force. It all has the same legal outcome and really the same logical underpinnings, that there was a real, in the sense of subjective, but an irrational, unreasonable belief in the need to use that force. So you don't get acquitted, but it may mitigate what would have been murder, or in this case, attempted murder, to manslaughter or attempted manslaughter. And no gun residue doesn't mean there was no gun fired, folks. That's like DNA evidence. The absence of DNA evidence doesn't mean the person wasn't there. It just means you didn't detect any DNA. The absence of gun residue doesn't mean a gun wasn't fired. It just means there's no gun residue. If there is gun residue, you know a gun was fired. If there is DNA, you know the person was there. But the fact that the presence of the evidence affirms some fact does not necessarily mean that the absence of the evidence means the event didn't occur.
Mr. McGrain, were you shown a copy of that statement before you came into courtroom today?
No.
Mr. Blancas or Mr. Deininger never showed you a copy of
Oh, that
what you
was
said
it.
to refresh your memory before you testified?
So they came back from sidebar.
Judge, for the record, it's a video.
So the sidebar occurred while this guy was under direct by the defense, and the defense asked the question and the state objected, and the lengthy sidebar happened. And what happened when the sidebar was concluded? Obviously the objection was sustained. The defense had no more questions to ask. And so now the state is on cross.
Video that the
All
prosecutor.
right, I get it. He wasn't shown a video. Here's your witness.
And you don't recall whether or not you ever said that during your interview the day that Lauren Canrek got shot?
It was 2.5 years ago. I can't recall what I was asked or said.
Do you remember when the police officers asked you questions about 911 calls in the week or so leading up to the shooting?
Not specifically. I don't remember.
Do you remember that there were 911 calls in
Yes.
the week leading to the shooting?
Yeah.
And were you at the property when some of those calls were made?
Yes.
Were you at the property when some of the occasions when the police came?
Yes.
And did you think that it was overreacting to call the police?
I didn't know the severity of the situation at times, so I wasn't sure.
But on August 7th, when you met with the police after the shooting and gave them a statement, you told them that it was probably a little overreacting by calling the police.
I may have said that. I'm not sure how I said it.
So just so everyone knows, one of the issues here is that Michael Barisone kept calling the police on 911, and the police kept showing up. But there was nothing for the police to do. There was no actual criminal activity taking place. Michael Barisone was upset for good reason at his treatment by Lauren Canrek and Robert Goodwin. But none of that conduct amounted to criminal offenses, which would have fallen within the purview of law enforcement. These were all civil matters. And the cops told them these were civil matters. And the cops were just getting fed up having to respond to calls to this property when there was nothing for them to do when they got to the property. So from the cops' perspective, all these calls to Michael Barisone were an overreaction. He needed to file a civil complaint in civil court to get this relationship dynamic addressed. It was not a police matter.
Do you also recall telling the police that nobody knew where the disagreement had come from?
Yeah, I don't even know how the whole thing got started in the first place.
No further questions, Judge.
All right. Any follow-up, redirect?
No, Your Honor.
All right, you may step down, sir. Thank you.
Just watch your step.
So Deininger, any other witnesses this afternoon?
Your Honor, we've run out of witnesses for today.
All right.
Oh,
I
thank
understand you have
God.
some witnesses tomorrow morning.
Yes, Your Honor.
All right, members of the jury, good news and bad news. The defense has no more witnesses for this afternoon. They do have witnesses tomorrow. Good news is you get to go home early today. So we'll pick it up tomorrow morning, same time. Please don't discuss the case with anyone. And do you know how many witnesses you have for tomorrow?
We have 2 lay witnesses, correct then?
I believe from 2 lay witnesses and 2 experts. I hope to get on tomorrow, Judge. And then we're done.
All right, and so we'll have a full day tomorrow with 2 lay witnesses and 2 experts. So we'll hear that testimony hopefully tomorrow, and then if the state has any rebuttal. And remember, ladies and gentlemen, I said this at the beginning, you probably forgot, but on Thursday morning, we're not going to sit Thursday morning. One of the attorneys has a prior engagement. The attorney tried to get it changed, but was unable to do so. And it's a prior legal engagement with a higher court, so I don't have any authority to make them change it. So I have to abide by what the higher court schedules. They take priority over this trial, unfortunately. So the attorney's going to be tied up. So 1:30, we expect to be able to start. So just keep that in mind. We'll start tomorrow all day, hopefully get all those witnesses done. If the state has any rebuttal testimony, we'll start that on Thursday afternoon. All right? Please don't discuss the case. You're free to go. Enjoy your afternoon. We'll see you tomorrow morning. Thank you.
All right, folks. Looks like that's it for the day. Thank God. So the defense does say they have 2 more experts they hope to get in tomorrow morning. My expectation is those might be psychiatric or psychological experts, which might feed into the insanity defense finally, or perhaps a diminished capacity defense. So I guess I'll check in the morning on this case and see what's going on with that. If it does look sufficiently, I mean, the lay witnesses I have no interest in, but it'll be more of the nonsense we saw over the last hour or so. But the expert witnesses, if I can time it right, I'll do a live stream for that, perhaps delayed a bit from the actual court proceedings, depending on my schedule tomorrow morning. And then it looks like the state may have a couple of rebuttal witnesses. A lot of times the state says they do, and then they decide they don't need it. It's hard for me to imagine why they would need it here, but we'll have to see what develops there as well. So I do want to remind everybody, because it is, and tomorrow afternoon, I have another commitment, folks. So you might wonder what that commitment is. The commitment is our Law of Self-Defense Hard to Convict webinar. This is a 100% free webinar where we'll be busting a bunch of myths of self-defense law, myths that are very common. They're endlessly found on the internet, gun magazines, gun forums, retired cops who live down the street, the lawyer who did your house closing. These are mistaken understandings of self-defense law that, if followed, are very likely to end up with you in prison. So we want to bust those myths, because the myths, if believed, make you easy to convict. We want you to be hard to convict. So our Hard to Convict webinar, taking place tomorrow, Wednesday, April 6th at 2 p.m. Eastern Time, we'll do that myth busting, and we'll have extensive Q&A. So if that's of interest, you can learn more and sign up at lawofselfdefense.com/hard to convict. It's 100% free, but there are limited seats. And I think there are still a few seats left for tomorrow. If not, there are future dates for the webinar that you can pick. But you'll know when you get to that web page, if tomorrow's date is no longer listed, that means it's full. But when I checked earlier, there were a few seats left. If you're interested, grab one of those at lawofselfdefense.com/hard to convict before all those seats are gone. And I'll take a look at the questions that might have accumulated. Let's see. Law Self-Defense member page is good to go. What about on the super chats? Let me take a look. I know a few more have come in since what just happened? YouTube is not being cooperative. Let's see. So the Megan K, thank you for your contribution. She asked the battered person syndrome question earlier, which I've already answered. Sherilyn Moore, thank you for your contribution. Did the cops say no gun residue on Michael Barisone's hands? I addressed that one as well. And then a final comment by Sherilyn Moore. Thank you for your very generous super chat. She writes, the outcome depends on how many men on the jury who've dealt with a quote-unquote Lauren. Of course, the victim here is Lauren Canarak. I guess you could replace Lauren with Karen and get the same idea. Maybe. We'll see. Again, we don't get to see the jurors' responses to all these proceedings, so we don't have even that kind of sense of what might be going on in their heads. Certainly on the legal merits, meaning the evidence I've seen in this trial, particularly the cross-examination of Lauren Canarak and of Robert Goodwin, and the testimony we heard here today, testimony we heard of Lauren Canarak's lawyer yesterday. None of that would appear to me to buttress either of the perfect legal defenses here, the legal defenses, the hypothetical legal defenses that could lead to an acquittal, meaning self-defense or insanity defense. I don't see evidence in support of either of those. Imperfect self-defense also seems unsupported for the same reason. Imperfect self-defense is basically a crazy claim of self-defense. Diminished capacity, or a hope that the jury will just find Lauren Canarak and Robert Goodwin so despicable that out of pure sympathy, they'll cut this defendant a break. I mean, maybe, but it's not like he waved a gun at them and is charged with aggravated assault with a firearm. He shot this woman twice in the chest. He shot at Robert Goodwin. He's charged with 2 counts of attempted murder. It's a stretch, but of course, lawyers are stuck. Folks, lawyers are stuck with the facts you give them. You give them bad facts, difficult facts, it's going to be a difficult defense. Give them good facts. Make yourself, in fact, hard to convict. You make yourself hard to convict, and believe it or not, you can, in fact, be extremely hard to convict. Learn how to be hard to convict at tomorrow's webinar, tomorrow, Wednesday, April 6th, 2 p.m. Eastern Time. Sign up. It's free, 100% free, but you do need to sign up at lawofselfdefense.com/hard to convict. All right, folks, I'm going to wrap this up for now. We'll come back live with further proceedings probably tomorrow morning. We'll see what those expert witnesses look like. And until then, I would just remind all of you that if you carry a gun so that you're hard to kill, which is why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law so you're hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.